Morning, thank you.
Good morning, everyone. Welcome to the I'm ahead of myself, the April 13th sitting of the Massachusetts Appeals Court. We have 6 cases on the list for today, 3 criminal cases and 3 civil cases. We will take a break after the 3rd case. Each side, as many of you are experienced counsel and you already know, each side has 15 minutes to argue and there is no rebuttal. Your time is however you wish to use it, but you should know that we are very familiar with the record in the case and the briefs. So with that, I will call the first case. Number 2025 P1185, Commonwealth versus JENI RAFAEL Pinelo. Good morning.
Morning. Please the court, Adriana Condertesi for the defendant appellant. In a rape case, when a victim gives testimony to a jury, that testimony is always very emotional and very compelling and certainly difficult for the jury to hear. And of course, the Commonwealth's goal is always to look to admit prejudicial evidence against the defendant. That's what they're supposed to do. However, the evidence cannot be unfairly prejudicial, and that is what first complaint case law is all about. And here, the defendant contends that Officer Cologne's testimony was unfairly prejudicial and bolstered the victim's credibility, where really there was no other evidence of the rape. In the Commonwealth's brief, well, there's one thing I have to concede on, and that is, it is true that Officer Cologne did give the defendant's date of birth, which he needed for the count 1. So I'm conceding on that, but otherwise, the Commonwealth contends that Officer Cologne gave a brief summary, that he testified that he began the investigation on August 14th, 2019, that he spoke with the victim's mother, the victim's stepfather, and the defendant's cousin.
Well, let me ask you this. So Officer Cologne spoke Spanish?
Yes.
And the witnesses that he spoke to spoke Spanish?
Yes.
If the Commonwealth hadn't called Officer Cologne at all, and they got in the date of birth some other way, could the defense attorney have gotten up in closing and said, ladies and gentlemen of the jury, you heard no evidence that any police ever interviewed these witnesses who only speak Spanish?
It certainly wouldn't have weakened the strength of the Commonwealth's evidence. In this case, although he didn't testify that he believed the victim, there was no question that he did. He got the other officers involved, and any of those officers could have been the people who testified that they had commenced the investigation.
So can I ask you a question?
Yes.
You analyzed this issue under first complaint.
Yes.
And yet you agree that Officer Cologne did not testify as to the substance of what was said by mother or daughter, right? So victim or victim's mom. And so I'm wondering, if you will, how you bridge that gap. In other words, the first complaint doctrine applies in a situation in which the substance of the sexual assault is confided or revealed to another party, and case law is clear that one person, and that first person, can testify with certain instructions. Here, you concede, correct, that in the transcript is clear that there is no substance of the conversations. It's more general. This is, I opened an investigation. I spoke with A, B, and C. I took photos and something else. So why do you call that first complaint testimony?
Well, I have a real problem coming to terms with the fact that, like, for example, in the Bracero case, there was so much prejudicial evidence that showed that everybody believed the victim's testimony, that all these different people heard it. But because nobody said, well, we believed her, that was the rationale that, well, this doesn't implicate any kind of a Stuckage violation. And I think that that's the question that the court is asking me here. So while the case law seems to say, look, you're not going to have a violation of Stuckage unless somebody gets up there and says, I believe the victim. I mean, the argument that the defendant is making here, and it is very important to him, that just because nobody said they believed the victim, it doesn't mean that, you know, the mother didn't believe the victim, Officer Cologne didn't believe the victim, that the husband that told the mother didn't believe the victim. So all these different pieces of evidence about a complaint being made should really qualify as Stuckage violations.
So in other words, in your analysis, none of that evidence would be admissible. So except for the date of birth. Well, Officer Cologne could testify that the defendant's date of birth was X, thereby qualifying for the aggravated portion of the crime. However, the theory in the defense at trial was that this was fabricated, correct?
Yes.
And wasn't this testimony of Officer Cologne, didn't that work to some degree to defense counsel's credit more than anything else? He used that, in other words, to say, mother fabricated, mother brought child to the police station, and here you can see where this happened, right?
Yes, and that's not a point that's not in other case law too, but it still doesn't mean, but look, the reason why all that stuff is there in the first place is that obviously the Commonwealth doesn't feel like the victim's testimony and the first complaint witness is sufficient, and they want to make sure that.
May I ask you a hypothetical? Assume for the moment you had two different police witnesses.
Yes, Judge.
One witness testified to the defendant's date of birth and testified that there were interviews with mother, the father, a bunch of other people, tracked down, tried to find some other people but couldn't do it, and it just kind of described the investigation more generally, but didn't mention speaking to the victim. Would that be reversible error? Would that be a Stuckage issue in your view?
Again, yes, because the description of the investigation is something that Stuckage in those line of cases talks about, because doesn't that put the indicia of government reliability on the complaint when there's discussion about.
So just generically, in its only sexual assault case, right? Just generically saying, again, without getting into anything that even touches upon first complaint because the victim's not involved here, say, you know what, I was inside an investigation, I spoke to the defendant, I asked him his date of birth, this is what he told me, then I spoke to his cousin, and I it didn't happen here obviously, but spoke to this person, and I wrote up some reports, and then that's all I did.
But how is that probative? How is it probative of whether or not the crime actually happened? It's not. That's the argument that everybody makes all the time.
Right.
But nobody ever seems to be able to get further really than Stuckage with it.
And so you don't think that just as a general proposition, the Commonwealth in any sort of case has any right to present the fact that the police actually did a competent investigation of some sort, did something on the case, and it just didn't drop out of the sky into the courtroom and before the lapse of the jury?
Well, I think that in some cases, some fact patterns do call for evidence about an investigation. Mm-hmm. But in a case like this, in a case of an allegation of rape, where the victim is getting up, where you have a first complaint witness, anything else really is really just set up to vouch for the victim's credibility, where there really is no other evidence of the incident.
Why isn't it relevant to rebut a possible Bowden defense?
Well, in this case, there probably would be, but in this case, there wasn't one.
So the Commonwealth couldn't introduce evidence of what the investigation involved until the defense raises a Bowden defense?
Well, I certainly think that that would be fair. I mean, is what would allow the jury to assess the credibility of the victim and the fact that she did make a complaint to somebody and kept it quiet for reasons that a jury would obviously understand, and assess the case in that way without all these additional ways to vouch for the victim's credibility. These are
But
very
why do you
serious
say-
cases, and it's very important to the defendant.
Sorry to interrupt, but why do you say vouch for the credibility? Because in the cases that have been cited, there's definitely vouching, right? In this case, I'm not sure I understand the argument other than because a police officer comes to the stand and raises his or her hand and testifies, that somehow is making this case is absolutely true or it's absolutely false. Because the testimony has nothing to do with credibility. The testimony has to do with the actions of the police officer. So if we were to accept your argument, then we would be setting out new law, right? That in any sexual assault case, police officers are not permitted to testify about their investigative steps because of the fear that jurors will consider that testimony in an improper way.
Well, the court,
Right.
without doing that, the court could say, in this case, Officer Cologne really exceeded the bounds
What
of-
did he do? What was his testimony that exceeded the bounds? So what exactly was he allowed to say that you think fell within the parameters of appropriate or permissible testimony to explain how this case started, how this case proceeded? So where
I don't think
did he go wrong?
Well, first of all, I don't think a jury needs an explanation of how a rape investigation got started when you have the victim testifying to, well, this happened to me, and then I told my sister after a certain amount of time.
But why would that be any different than, say, in a murder case? Police officers testify every day in murder cases. I went to the scene, I took DNA, I spoke with 5 other people. There would be a different rule in sexual assault cases that would prohibit this type of explanation as to the steps taken to address a potential crime?
But carrying out an investigation is different than what a police officer might be testifying to in, for example, a murder case, because they always testify and explain and describe how they gathered evidence. We found the casings, we did these blood stains, we found, a knife.
Given this conversation, how do you respond then to the Commonwealth's point that in Commonwealth versus Arana, the SJC said, we do not intend Stuckage to imply that unless a police officer is the first complaint witness, testimony concerning the circumstances giving rise to the police involvement in a sexual assault case will never be admissible as part of the case in chief. In other words, so what's different here and distinguishable from Arana and what the SJC said there?
Well, except that the idea that just because a witness doesn't say, I heard her and I believed her, it doesn't mean that witness is not really bolstering the testimony of the victim.
Sure, like if they say, I talked to this young woman and then I went and sought a complaint, or then we went and arrested the defendant. Okay, that's pretty clear to why that might be inferable as, we believe what you said and so we acted on it. That's not what happened here though, right? Didn't say anything of the sort.
No, but it would be very difficult very difficult for a jury to assume anything except that the minute that Officer Cologne heard the complaint from the mother who heard it from her husband, he immediately believed her. But in that case, you do really have to ask, where is the relevance to the crime? So I don't have anything else in this case. If the court would like to give the defendant a new trial, I know that we could set it up so that it would be much more fair than it was this time. So I hope that the court will consider giving the defendant a new trial. I don't have any other questions. I'll rest on the brief if...
Thank you.
Okay, thank you.
Good morning, may it please the court. My name is Emily Walsh. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. During the brief direct of Officer Colon, the Commonwealth elicited that he speaks Spanish, the defendant's date of birth, which as counsel conceded is a necessary element, and that around August 14th, 2019, he went to Lexington Street and he spoke with the victim's mother, Honor, and Kevin. There was no testimony about what the individuals said, not testimony about their demeanor, no vouching for any of their credibility. He did not give details about further investigation beyond the fact of going to those places and speaking with those people there, and none of the testimony was improper. And the cross-examination emphasized the information from Cologne that the first report came only from the victim's mother and that Cologne did not speak with the victim. On cross, Cologne was asked, quote, "You opened an investigation based on what the mother had told you, right? Question mark. And Cologne answered in the affirmative. The defendant then made that the theme of his closing. The theme of the closing was that the mother was an abusive mother who forced her daughters into roles that were, quote, puppeteered for immigration status. In closing, the defendant stated, now the mother is forcing the victim to tell you this story. And when did this incredible story begin? Let's remember, it wasn't the quinceañera. It wasn't after the wake. It was when the mother herself goes to the police station and forces the victim to go with her. And also, let's remember how the story is told. It's not the victim speaking to police that day. It was the mother. She created that story.
I understand your argument that the direct examination of Officer Colon was very bland. Should we be at all concerned about the fact that the prosecutor asked, when discussing the officer's interview of the cousin, and during that conversation, what were you talking about? And Officer Colon responded, some allegations that someone had made.
What the prosecutor was trying to do, if you read the entire transcript, but also that part of the closing, back during Honor's testimony, there was an interpreter. He did not testify as the prosecutor expected him to about what the defendant said to him. And then at sidebar, this is page 37 to 46, there's an extensive interchange with both attorneys and the interpreter about whether he understood the question properly. Is your memory exhausted versus do you remember that? One is answered no, one is answered yes, and that confusion. And the prosecutor was attempting to get that in. And it didn't go anywhere. It was objected to and sustained. So even if that question was error, there was no answer. It was objected to. The testimony didn't come in. And then the content of Colon's testimony was the heart of the defendant's closing. And under the case law, where the defendant embraces the evidence that he now challenges, it's hard to see how there could be a substantial risk of a miscarriage of justice.
As a more general proposition, your take on the Commonwealth's right, or at least ability to put in, I suppose, Bowdoin anticipatory evidence?
Sure.
What's your thought on that?
As Judge Grant mentioned, we need to show we did a good investigation, or that will be used. How deeply it's used, whether a Bowdoin instruction is given, that's not clear, but we need to show that we did an investigation. And the
Do you need to wait until the cross-examination that might bring that up, or do you think you can just do it as a matter of course in any case?
I think that it is nuanced. I don't think that you need to wait until cross-examination to bring it up, but obviously there's a line. You know, the case law, this is Commonwealth versus Condon, 99 Mass Appeals Court 27 from 2020. The case law recognizes a tension between allowing police witnesses to let the jury understand the investigative steps they took, and the risk of gratuitous references to such an investigation could provide undue credence to the underlying allegations. It's a well-established tension in the case law that the Commonwealth needs to proceed carefully on. But in this case, they weren't anywhere near that line. The minimal testimony there was absolutely nothing prejudicial in it, and then it was embraced by the defendant in closing.
What about where the question was after the conversation you had with so-and-so, because of what he told you, who did you talk to next? And that's at page 31 on fourth day of trial. When you throw a because in there, doesn't that seem to suggest to the jury that you got some information that led you to a different place.
I don't think that is a problem. I think showing that you got information and that it led you somewhere is an investigative step, showing that you didn't just do nothing, that you didn't just, you got a report and here you are at trial, or that there are things that happen in the interim. That's not vouching, that's not substitute first complaint. I think that is permissible under the case law.
I mean, I guess the argument could be made the same thing about the photos. Why would a certain, right, why would the officer or detective take photos of, for example, a bedroom or a basement as a result of certain conversation? This is what he or she did, right?
The fact that you are at the trial you are at and that there is an officer who conducted an investigation, I think that this is the kind of thing that, as in Condon, you can't put officers in the fake position of having just happened upon a crime and then happened onto the witness stand. There are things that happen in the middle, and some explanation needs to be given. If there are no further questions, I'll rest on my brief.
Thank you. Very well argued by both sides. The next case is 2024 P1390, Commonwealth versus Vincent Grant.
Good morning, Your Honors, and may it please the Court. My name is Ethan Stiles, and today I come to speak on behalf of Mr. Vincent Grant. And we bring three issues to the Court's attention.
Could you just move the microphone a little closer to your mouth? Thank you.
And so we bring three issues to the Court's attention, and the third issue, the Gordon issue, has been conceded by the Commonwealth, and the co-defendant has already been allowed her motion for new trial by the trial court. So let me focus, unless the Court has questions on that, on the issues that are in contention, namely the search warrant and the sufficiency as to the trafficking charges. Now, when it comes to the search warrant, we have a claim based on a confidential informant and some controlled buys. And I would suggest that those buys did not meet the standard that was required to show that the informant's reliability was shored up by the investigation that followed it. Because we have no indication of this informant's reliability. It's a confidential informant. And so we must look to other facts in the affidavit that would suggest this person is reliable.
Can I ask you, the case law on this is pretty old, and what's missing here? I mean, I'm struggling to find out on on what the police did in terms of supervising the controlled buys, that what was missing from the steps that they took as opposed to what they should have taken.
So as to the controlled buy, let me focus on exactly what they claim to have done. They said they heard the informant arrange a deal. They searched him. They saw the informant approach the vehicle, and they saw the vehicle leave, and they saw that vehicle. Oh, sorry. And my timeline is, they saw someone enter the vehicle from the house, go to the location agreed to. They saw the informant approach the vehicle, and they saw he was there for a moment. It was there for a moment, maybe a minute, and then the informant left. They found the drugs on the informant, and at least on one occasion, they followed the vehicle back to the residence. The other two, they did not.
And they pat him down beforehand, right?
Yes, they patted him down beforehand.
Okay, you may have said that.
So no drugs, only the money that they gave him, right? So, but the critical component missing is the fact they did not escort the confidential informant to the location. So you have him here, he makes the deal, and then the next time you hear about the informant, he's at the meat site and he's talking to the person whoever's driving the vehicle. And so in between that time, we have nothing. And
Wait a minute. So the paragraph 20 of the affidavit says, I observed the informant approach the passenger side door of the Rover and briefly reach inside.
Yes.
Are you saying there's a problem because they didn't follow the informant from point A to point B?
Yes. So there's nothing in the affidavit that said, I accompanied the informant from where he made the call to the buy site. So, and I think that's critical when you are dealing with an informant who has no track record for reliability.
Do you have any case that says that or close to that? Because I didn't see it. And maybe it's in your brief and I missed it, but.
I don't see anything that goes exactly to that, but I think if you look at the case law that actually where the court actually talks about the controlled buys, what they expect the SJC does. I forget the case name, but when they say that, that's like number 3 on the list, and I suggest that number 3 is not present here.
So if we break it down, a basis of knowledge seems pretty clear, at least if you accept the affiant's statement that he said, I bought drugs from this person, right?
Yes.
And then on the nexus, are you also contending that there's not a sufficient nexus, even where the police write in their affidavit that they saw the defendant and the co-defendant come from the house, get into the car, go to the meat site, and then at least on one occasion go back into the house? You think there still needs to be more for the nexus to get into the apartment, I should say?
Nexus, given those observations, and we must, and we rely on the papers here, nexus is not, to me, the key issue. The key issue is what is the informant, not the activities. Although I would note that that we saw people leave the house. So and he says, well, this is Vincent Grant, this is Netria Haywood. We don't know if that's true. Because we don't have the police officers say, oh yeah, I looked at their licenses, and yeah, they look like these people. So we don't have that. But anyway,
okay.
But the most important part is that when we're dealing with an unreliable informant, there should be greater care to follow the steps as outlined for a proper control buy, or the police could alternately be prepared to explain why they couldn't. For example,
So is your concern that after the police have searched the informant and determined that the informant doesn't have any drugs or money on their person, that unless the police conduct continuous surveillance of the informant might get drugs or money from someplace else?
Yes.
Is that your concern?
that's my concern. Or just fake drugs, because we don't have a field test here. We do have a weight, but we don't have a field test. It's just, okay, he's come back with actual drugs. So now let me turn to the second part of the warrant argument, is namely the no-knock and the nighttime search. Now, we have here in the affidavit the standard observations that drug dealers can quickly dispose of the evidence, drug dealers can be known to be violent, and when...
Assume we're with you on that one. I don't want to speak for everybody else. Assume for the moment I'm with you on that one. Talk me around the fact that they put in there that your client had his LTC revoked because of an assault and threatened to shoot someone, and that the co-defendant has a 9mm.
All right, well, let me begin with the observation that it seems to be pretty uncommon at best that suspected drug dealers actually have LTCs or FID cards. Usually they...
You're saying uncommon?
Yes.
Yeah, I'm with you on that one. Okay.
So, and what we have here is we have one allegation, and I suggest, and it is an allegation of violence involving the weapon. But if you actually look at the facts that are alleged, you can see that first of all, the violence had no obvious connection with the drug trade. Second, that there was no other indication that this 68-year-old man had any kind of criminal history beyond this thing. And third, that the actual threat was conditional. He said, touch me and I'll shoot you, which might seem a little aggressive, but then again, he's 68, and a touch for him might be a little more than a touch for you or me. So you have that, and we don't have, typically when we see the case law, we'll say, okay, he has drug convictions, he has multiple arrests, he has a domestic assault and battery.
What do we do with the fact that there was no conviction, but this incident had only happened less than 2 months before?
Well, I mean, again, considering, that there is, one instance in the life of an elder, I'm not sure what you can really take from it. But I would note that his firearm had been seized. And there was no indication, oh yeah, we've observed him, we've seen him with guns, he loves guns, or anything like that. And I would also point out that these people weren't known to the police. They weren't known to be, career drug dealers. They certainly didn't have records. So they didn't see them engage in this kind of behavior with any other person. So again, you're relying solely upon the CI to supply you with facts that can help you. You don't have, the officers, seeing him go to a bar, as I think it was the O'Day case, where he was conducting similar transactions with a bunch of people over the course of hours. You don't have that here. So essentially, all you've got to show beyond the generic drug dealers, they get violent, they destroy evidence, we don't, and you can't approach the house from the road, and I would suggest that's a little a trifle ambitious, because, there's no indication that the house was enclosed by a fence, or they had they had cameras all about the place, or they had motion detectors, or they even had a dangerous dog that liked to bark. We don't have anything like that. And we have, or the trees were so thick that you couldn't walk through the trees if you wanted to get.
I would agree with you that if it was a very generic, the house is in a shady part of the street argument, that ought not be enough. I'm suggesting that a recent allegation of an assault with a gun in a short time span, if there was going to be a case for a no-knock warrant, that would certainly appear to be sufficient at a minimum to allow police not to give a heads up to the inhabitants who had a weapon, to let them know they're coming in to pay a visit, right? I mean, you'd have a really strong argument if it was just a shady house and someone with no record and the generic drug dealers carry guns. Unfortunately, in the facts that you're arguing, your client just had a gun brandished, allegedly, a few months beforehand.
Yeah, yes.
Makes it tough.
But nonetheless, I would suggest that one singular incident is not what the cases tend to look for when they're looking for evidence of violence or activities that would suggest these
Do
people.
you have a case citation for that one brandishing of a weapon in recent time is not enough to suffice for a no-knock warrant?
No, I do not. But I point out cases that, typically talk about these things. They usually talk about more than just one instance.
Sure. Can I turn you for a moment to the sufficiency argument?
Yes.
Was there any evidence, and if so, could you point it out, that the baggies, because it looks like the Commonwealth concedes that we're talking about the pink can and the Bureau drugs, but is there any evidence that those were in a Ziploc as opposed to corner cuts?
No,
In the light most favorable to the Commonwealth, is there any, I'll ask it as I asked initially. Is there any evidence at all other than that those were in corner cuts, which are not Ziplocs?
I don't think the record is clear on that, Your Honor.
Okay.
Because, first of all, we don't have the actual original bags. They weren't, because what happened was the police take the bag, they weigh it on the scale, and then they send it to the lab. Now, the lab takes out of the bag, they do their weighing and their testing, and for reasons that are explicated by Gordon and prior case law, that's not in, but you still, when the jury
But here, at least to the extent it came in that regard, the weighing that the officer did was before they go down to the lab and they put in the outer, bigger baggie that's going to weigh significantly more than the corner cut.
Yes.
Right? Okay.
Although,
And so if it's only the corner cut, why is it not just a math problem like the Commonwealth says? You got 24 grams, and from the description, if you take it in the light most favorable to the Commonwealth, or even in the light least favorable to the Commonwealth, it's 2 grams per bag, and you do the math, that's 24 minus 6 is 18.
well, I mean, it is extremely imprecise the way that's done, where the standard appears to be precision, where you have whatever the preliminary weight is, it goes to the lab. They empty out the stuff on the bag, they put it on the scale, they weigh it.
So let me ask this: in a required finding, though, for a required finding, is the standard precision? If we're assuming they're admitted and they're part of the evidence, and whether they should have been admitted is a different question, just on that, but they're admitted and they're part of the evidence. Is precision really, where do I find that precision is part of the calculus that the judge ought to have done in motion for required finding that we ought to do here, applying the same standard to a sufficiency analysis?
Well, I mean, the important point is, I think, that that sometimes the evidence just isn't good enough, and that's one of these cases when we're dealing with tiny amounts of weight here that separate a possession with intent from a trafficking charge. That more is required than just an officer just putting the bags on a random scale and saying, I add up 24, and 6 more than 18. Yes. So more.
Should we be writing a case to encourage police to dump the drugs out of the baggies onto the scale when they weigh it?
I would suggest that should be done at the lab. In this case, it could have been done at the lab, but again, we have an issue that predated Gordon that says, you know, that the chemist doesn't weigh it, that's not coming in, and the Commonwealth knew all about that. So we're not even, this is pre-Gordon stuff here. So ultimately, what we have here is a random scale, and some of these bags are twisted, some of them are, you know, all these bags, there are six bags, you know, we only have photographs of the bags. We don't actually have the bags themselves because they were weighed and put in the state police the lab packaging. So the jury doesn't even have the original bags to even look at through the evidence bag, which they were told not to open, to see, you know, hey, does this weigh up of 18 grams? And I think, you know, the case law that I've cited even suggests that that jurors cannot reasonably be expected to make such a weight, you know, just considering how minute the quantities are. And so in this case, we are dealing with bags of various shapes and sizes. But let me speak to your point, Judge, that we do have corner cut bags, but where they came from, whether they were from, you know, the lighter foldovers or the heavier Ziploc, we don't have that. And we can't really see that because all we have is the actual photographs, and not very good ones of that, in evidence. And I think, and I've included those in my brief. You can take a look at them. I think they are, let's see, exhibits 42, 43, 58 versus the actual bags that the lab used, which is at exhibit 60.
I think your time is up, and we'll have to leave it there.
All right, thank you very much.
Thank you.
Morning, Your Honors. My name is John Carmody. I'm an Assistant District Attorney at Cape and Islands District. I'm here on behalf of the Commonwealth. May it please the Court. If I could just briefly go to the weight issue. We've assented under Gordon to a new trial. I believe that takes us back to square one. When we go back to trial on this case, the Commonwealth is going to have to prove all the elements of the charge. The conviction will have been vacated.
It's an interesting question, though, where you seem to concede that the larger bags, even though at least one of the purses was in the same file cabinet, right, with some of the...
Yeah.
Yeah, but do you think you could go back now and argue that, well, let's look at all 200 and some odd grams?
You know, I don't, it is, you know, not to copy you, but it is an interesting question. Based on the jury's verdict, it did seem to me that that was the only way they convicted him of what.
No, and I commend you. I think you're right, but
when we go back at a new trial, because both defendants are getting a new trial,
right,
we're starting at square one here. Huh. So I don't know if the jury will agree, disagree, if they're going to come out the same way the next time, but we are back to square one with a new trial. Okay. So at the new trial, the jury may attribute all the drugs to the defendant. I don't know how the jury will view it. But on that thing, I think the weight issue becomes kind of moot here. But to the argument we made in the brief, you know, the evidence was in front of the jury. We had two officers testify, weighed them, what they weighed in the baggies. We had another officer testified what baggies typically weigh. If you even given the defendant that the jury went to the maximum weight of the corner baggies, the jury's able, as Your Honor said, to do the math, and it added up. And that's what they convicted him on the weight. But again, I don't think we need to go to the weight here.
So can you talk to me
that?
for a moment again about that? So when the Commonwealth concedes that there was a Gordon issue and because of the state of the law, so not because of any intentional conduct, and you go back to the beginning. Mm-hmm. Any error during the trial we don't address as far as if there is an issue about the sufficiency of the evidence and the weight of the bags versus the weight of the drugs.
But I think those, I'm sorry.
Yeah, no, go ahead.
I think those are, it goes not to the sufficiency of the evidence there, it goes to how much weight the jury gave to the testimony that the police officers gave. I don't think there's any error there. That's the jurors gave great weight to the testimony of the detectives and calculated in their own head that it came up to be 18 grams. I don't think there's an error of law there.
So, again, I'm just trying to understand this argument because I don't honestly think that I gave it as much consideration, which is if there's a new trial, then the whole new, potentially different evidence coming in about whose drugs were whose or what the jury considers or what have you. So we don't need to reach the issue of.
I think that's in any case where there's a new trial granted, we start back at square one and we have to prove, the Commonwealth has to prove every element of the crime charged.
So I actually agree with you, and I'm not sure that we can look behind the jury's verdict necessarily. Having said that, at page 29 in your brief, you say the inescapable conclusion is that the jury did not find that the defendant and Haywood jointly possessed all the alleged narcotics. Specifically, it is clear that the jury ascribed the drugs recovered from the filing cabinet to Haywood and ascribed the alleged drugs from the nightstand and the console to this defendant. So how do we work around that, and how are you then not stopped from making a different argument at trial, on the new trial?
That's the only interpretation of the verdict.
Right.
That's the only interpretation of the facts that supports the verdict in that case with the evidence that was put forward in that case.
Right.
When this case goes back to trial, and part of the reason that that happened, that the jury came that way, is that there were statements by the co-defendant, okay? Those statements, I mean, it's outside of this defendant's, but they're in the process of being relitigated again.
But so I get that. So then on a sufficiency analysis, is what we are doing, is it your position then that we can look at the entire transcript and say, there's over 200 grams here, so if he got convicted of 18, there's certainly enough, I mean, no matter what anything weighs, to get over the rail on 18. You get my question?
Yeah, kind of, yeah.
All right.
I mean, I'm really.
I mean, even though they're saying this is what the jury most likely
did.
did.
Point that we're starting from scratch here, and that they may get a totally different outcome this time with a different jury. But
right.
And depending, and it really does depend on what happens on the other motions to suppress.
Let me put my question a little better and more pointedly, which is our sufficiency analysis, does it include in the light most favorable to the Commonwealth all of the drugs that were offered in evidence, or only the drugs that came from the nightstand and the cabinet with the paint can?
And I think we're getting into a bit of a catch-22 here, because what we have here is we have assented to a new trial, so the conviction would be vacated. Yep. And once the conviction's vacated, we go back to square one. I know I'm repeating myself, but
they're saying square one is limited by what the jury found. So, for example, in a murder case,
if
they only found a manslaughter, we don't go back and get to retry the murder again. You're stuck with the manslaughter. Here, the charge was over 200. The jury came back with 18 and over, or over, right? And
18 and over.
Yeah, and so is our sufficiency, when we consider the sufficiency argument, are we looking at every bit of evidence that came in, or only as it relates to what you concede is what the jury most likely considered to get to 18, as opposed to over 200?
I guess my response to you is you don't need to look at the sufficiency argument at all, because we're starting over again with a new trial. If we assent that the conviction should be vacated, the entire conviction is vacated. So I don't believe the court needs to look at the sufficiency of evidence.
Okay.
What do you say to the defendant's argument that in a search warrant affidavit, the police should be required to conduct surveillance of the CI from the point in time when the CI is searched up until the point when the CI arrives at the location of the buy?
Okay, so what happened in this case is that the Detective Kelly was with the CI when he called the defendant's phone number and arranged for the buy. That's in his affidavit. He calls the number he has, he hears the conversation, he watches it, and they arrange a meet location. There's one paragraph of the search warrant. It's paragraph 38, where Detective Kelly says, I then established nearby surveillance. I don't know what nearby is, but the implication there, the inference, the reasonable inference from the search warrant is that he was there when they arranged the buy. He sets up surveillance so that he can watch the buy. Everything else is, I would submit that the entire buy is textbook.
That's the third buy. There's 3 buys, so yeah.
So what he does is in the affidavit, it does say that I witnessed him set up the buy, arrange the meet location. I set up surveillance. I could see the meet location. I kept my eye on the CI. I searched him. He had no drugs on him. He had no money on him. The only money he would have is the money I gave him. He goes, I see him go to the car that he described. He went there. He sees the transaction going on. CI comes back to him with the drugs. There's no break there. He takes the drugs. He gets searched again. There's no other money. The money.
So I understand your argument, just sorry to interrupt. I understand your argument to be that if we read the affidavit correctly, there's no break. It's not like they were they did the call from the station and set up a meet location, and then they says, yeah, we'll meet you over there. And then, however long later, they surveilled the meet location. You're saying that the inference from this is that they had eyes on the whole time.
That's the inference, but even if it wasn't the inference, he does say he searched him before he approached the car.
I think counsel's point, though, is that, yeah, you searched him before, but then who's to say what he did? If you lost sight of him for 5 minutes, who's to say what he did in the interim?
Yeah, I don't think that is a reasonable inference to be drawn from the 4 corners of this affidavit.
On the no-knock part of it, I'm just going to ask you a couple of, what do you think, what if it was just the 9mm, the co-defendant with the 9mm in the house? Does that get you no-knock?
Yes.
Okay. And then I'd say for sure then your position is that the 2 weeks ago, the assault with a gun gets you there.
Yeah, he brandished the allegation.
The allegation,
But
but
he
sufficient for the
brandished
affidavit.
the gun in daylight.
What if it was a
during
hunting-
an altercation.
What if it was just a gun in the possession of the co-defendant and it was a hunting rifle? Would that get you there?
Yes.
Any firearm would get you there?
Yeah, we know that, we suspect that these two are dealing drugs, right? We know for a fact that you want to just talk about the co-defendant. It has a gun. We know they have a gun. They have a license for it, and they have it. It's
What's your
registered
case
to them.
that's the closest to that says that going to execute a warrant, if you know there's a gun in the house, that's pretty much an automatic no-knock?
I would say it's, I think it's really any case that goes to the officer's safety. If you look at, I'm trying to think here. The flip side of it being, I guess I'm going to argue the opposite under the Jimenez case, where the court made a point of saying there was no allegations that the officer had any reason to believe that there were weapons at the premises or the defendant may have a gun. I think the inference
corollary
being,
is,
if there was, it would have been sufficient. If there's no further questions, I will rest on our brief.
Thank you very much.
Thank you very much.
Our next case is 2025 P280, Commonwealth versus Anthony Villalobos. Morning.
Morning, Honorable Justices. My name is Attorney Terry Treviakis on behalf of the appellant, Defendant Anthony Villalobos. May it please the court.
Counsel, do you mind just pulling the mic a little bit
Sure.
closer? Perfect.
I
Thanks so
apologize.
much.
Thank you. So in this matter, the Commonwealth officer proceeded on a theory of joint venture in the attack upon the victim where clearly several people were involved. Ultimately, however, at the end of the day, the evidence presented, there was insufficient evidence to establish any knowing participation by the defendant and any shared intent required. There was simply no evidence presented that Mr. Villalobos participated in any way directly or indirectly in the attack. At best, the evidence established only mere presence. Notably, there were no witness, not one witness, identified Mr. Villalobos. The group at trial was identified, if you want to call it, by the witnesses as the Tuxedo Group. And each and every single witness by the Commonwealth referred to this group as the men wearing red and black tuxedos. What's important, though, in the evidence is that Mr. Villalobos was not wearing a red and black tuxedo. He was distinguished apart from his friends or other people within that group because he was wearing a distinctive black T-shirt with a white backdrop with a photo of his deceased friend, which that group had gone to in memory of that evening. Witnesses testified that there were several members of that group that were wearing red and black tuxedos, but there was no definitive number on how many people in that 20 to 28 person group were wearing them, only that most of the people were. Mr. Villalobos was obviously not one of those 20 to 20 people with that attire. And certainly we know that from the evidence that not all of those 20 to 20 people were involved in the attacks upon the victims. What we do know from the evidence and the witnesses that were present is that it was less than half that group that was involved in these attacks. And one witness testified that there were 3, perhaps up to 10 people. One witness, I think, testified that there were perhaps, he estimated 15 people that were involved, but most witnesses testified that there were only 10 people involved. And so immediately we have less than half the group that was even involved.
What do you say to the Commonwealth's argument that the video shows at 2:06 a.m. the defendant moving away from the limousine and walking up Connor's place, joining the other men in red and black as they rushed at the victim?
Well, first and foremost, the video, Exhibit 130, I believe, is at your disposal. And if you were to watch the video, it does not show that the defendant rushed. I take issue with the characterization that
Well, they don't say he rushed. They say he joined when the other men who rushed.
I don't see the video as illustrating that he joined the group. But if you were to watch the video shows the a large group going towards, proceeding down Connors Way towards the intersection of Connors and I believe Columbus Avenue, and then taking a right. Mr. Villalobos is not joining that group. He kind of stays back.
Yeah, what do you say he's doing? Because I watched the video, but we watch it, and it's a little blurry.
Right.
But even as you watch it, what do you think he's doing?
I think, again, this is the
Monitoring, watching,
Well, this
as
is-
opposed to participating? Because
Right.
you clearly don't think he's participating.
to answer the question, I think is indicative of what the jury was presented with, and this is speculation and conjecture. I don't know what he's doing, and I don't think the jury knew what he was doing, and that's the whole problem with the Commonwealth's case. To know what he was doing would require, there's no direct evidence that illustrates what he was doing, and so the jury has to have had engaged in conjecture and speculation.
Well, why
He
would
could have been,
why would they have to when you look at everything in the light most favorable to the Commonwealth? I mean, you have your client sprinting to get to the head of the pack at some point, right?
I would disagree with that
Right, well,
characterization.
that might be a little bit more than you'd want to admit, I understand, but your client in the group, and you can dispute what or whether he's doing something right then. You have a testimony from witnesses who say all of them were attacking. You also have, and I understand it's not the victim's blood, but he has blood on him, correct?
Well,
I mean, that's something. You usually don't go to a nightclub and come out with,
Or a funeral.
or a funeral, true, with blood on your person.
well, with regard to the blood, number one, the blood was analyzed, and it was excluded as being traced to any of the victims, okay?
No, I understand, but it's indicative that something happened
Well-
to your client that resulted in an injury, a recent injury. And so, of course, if it was one of the victims, boy, that would be really strong evidence, but it's something. So when you say there was insufficient evidence, I just, looking at it in the light most favorable to the Commonwealth, as we must.
So to answer your question,
Yeah.
the evidence, the only evidence is that there was blood on the victim's pants. There's no evidence as to when that blood, that was his own, was on his pants. The jury heard no testimony as to when that stain was presented on his pants. Was it 5 minutes earlier? Maybe. Was it 5 days or 5 months earlier? That's also a possibility. Again, once more, the jury would have had to engage in conjecture and speculation, even as to
So
that.
can I ask you on that, because that certainly occurred as I read through this. Is it your position then that that has zero probative evidence because they
Zero.
cannot put a time on it?
Zero. I think it's wholly different were the situation, for example, if, and I'm not a forensic scientist, but if, for example, the blood was fresh or it was wet, that's different. If perhaps the blood was traced back, maybe perhaps.
Should the judge have excluded it from evidence?
I would, if I were trying the case, I would have certainly moved to have excluded it based on relevance and staleness, but I think it would have been a different situation, for example, if the defendant, unlike his, other co-defendants, if the defendant had fresh cuts on his hand, if he had been bleeding in some way, the jury would have then been permitted to infer that, yes, that blood stain perhaps might have been fresh and on his pants.
Doesn't that go to the weight? I mean, in other words, if you have a ripped shirt, you don't know when it ripped, but most likely,
Well,
the jury could infer that you wouldn't go to a nightclub with a ripped shirt. And nobody can testify as to how it was ripped or that it was ripped, but it's something for the jury to consider. Was this person involved in something that resulted in a ripped shirt? And I see the blood evidence as very much the same. Common sense would say, generally, you don't go to a nightclub or a funeral with blood on your pants.
well,
And we don't know when the blood, if it was 10 years old, 10 days old, or 10
Right.
minutes old, but.
the pants are black, right? The pants are black. And there's no testimony that the pants were, the blood stain was visible on black pants, number one. I disagree respectfully with the court's rationalization. I don't think you can make that analogy to a ripped shirt, that because there was a blood stain of an undetermined time frame on black pants that may or may not have been visible to the naked eye. We don't know that. There was no evidence
So
that.
I don't recall, but I suspect you do. Was there anything in the record that quantified the blood? Speck of blood, spot of blood, big, huge blood stain?
My
I don't think there
recollection
was
is
anything,
no, only that
Just
there
said
was.
blood,
Right, there was just a blood stain. I don't recall, and I apologize, there's no.
It's okay.
But your argument is that doesn't go into the kind of calculus of, in the light most favorable to the Commonwealth.
No,
It's a zero.
Respectfully, no. Had there been something more, had there been evidence of direct participation, had there been evidence that Mr. Villalobos had a cut on his hand, something other to permit a reasonable inference.
So if we were to find an old case about a homicide, pre-DNA, pre-ABO and serology, and the SJC said there was blood on the defendant's pants and that's relevant, we could no longer rely on that case?
I think with the introduction of DNA and the advancements in technology that are available today, that there's an argument that no, there probably would not be a sufficient reliance. Again, without other indicia of evidence of participation, there has to be something else. And at the end of the day, if this is all the government has in terms of evidence of direct participation, because once more, on the video, you don't know what he did, if anything, once he turns the corner.
Is it your position that in order to prove that the defendant committed involuntary manslaughter by wanton or reckless conduct, the Commonwealth had to prove that the defendant landed a blow on the victim?
No, but he had to have had participated in some meaningful way. And that's the issue here. There's no evidence of participation in some meaningful way. This is a classic case of mere presence. Yes, the video shows that the group moved towards the intersection, took a right. Yes, sometime thereafter, even a short time, the defendant proceeded towards that group and took the corner. The problem becomes, though, however, is that once the video, because the video doesn't show what happens after the corner, we know that the incidents occurred towards the next block up Stanhope Street, which is the next block. There's no evidence as to how far up the block it occurred.
But you can see a blurry white square in the midst of the people at the top of Connor's Place.
I don't believe that was Mr. Alicea. I think because there were 3 other victims, and I recall from the testimony and the evidence there were 2 kind of separate fights for which Mr. Villalobos was found not guilty of in previous trial. My understanding from the evidence is that the incident with regard to Mr. Alicea happened further up towards Stanhope Street. And so once more, the video stops at the corner. Again, we don't know, nobody knows.
It happened towards Stanhope Street, but I thought that the off-duty Boston detective testified that the victim's body was in the right travel lane of Columbus Ave.
Right, but towards Stanhope Street. I'm not saying that it was on at Stanhope Street, but it was towards the area of Stanhope Street. And so, once again, once Villalobos turns that corner, you know, even if the jury were permitted to find that it was more likely than not that he joined in and participated in the attack, that's not the standard for which this court is able to determine that he was involved as a joint venture. The evidence has to be able to permit a rational juror to be able to find beyond a reasonable doubt that he did so, and it just doesn't. Is it just as likely that he turned the corner and stopped and saw what was going on? And I would remind the court, he did return before the other members of the group returned from the...
When you say he turned the corner, so are you saying that the actual beating of this victim was not visible on the video?
It was not.
Why can't we infer that the crowd that we can see in the video with the blurry white square at the top of Connor's Place isn't the crowd beating the victim?
Because that if you, from the trial testimony, all the witnesses, my recollection is testified that the assault occurred beyond the corner towards the area of Stanhope Street. And so all you see in the video is the straight shot of Connor's Place, I believe, and then the perpendicular cross street of Columbus Avenue. So you see a group of individuals that proceed towards that corner. They go off to the right. You don't know anything.
You may have said it, but what you're arguing, just so I understand it, is that the skirmishy thing that we see on the video isn't necessarily the murder or the killing.
Correct. That's my understanding from the, because they were, again, 2 separate, almost contemporaneous, almost simultaneous, but they were 2 separate incidents.
And there's record evidence that more than one person is dressed in a similar way
Oh, yeah.
to your client.
Oh, yes, they were.
With the white blob. I mean, to me, again,
no,
it's not.
No, only
Okay.
Mr. Villalobos was dressed in the black T-shirt with, on the back.
On the back, yeah.
There was a picture of his deceased friend against a white backdrop.
Okay.
The testimony was most of the other individuals, which between 20 and 28, were
Right,
dressed in
had
red and
tux,
black tuxedos. Mr. Villalobos, again, was not wearing red and black tuxedos. I know my time is very close. I would just want to point out that the government cites several cases, and I don't have time to list them all, but in every case cited by the Commonwealth, there was evidence of direct participation in some way by, in those cases.
By direct participation, do you mean a battery?
In some way, yes. There was either the defendant had a knife, he committed an assault, he punched the victim. There was some evidence of direct participation of which there is none in this case. Thank you.
Thank you.
Good morning, and may it please the court. Mackenzie Slyman on behalf of the Commonwealth. The Commonwealth's case here was sufficient for the jury to convict the defendant of joint venture involuntary manslaughter. The 2 most critical pieces of evidence that the court need look at and go no further is the surveillance video from which it's clear the defendant with a very distinct white square on the back of his shirt is seen moving from the limousine he's staying by up towards the group. And I'll pause there and discuss that for a moment. The cameras, all 4 that went into the jury, and that's Exhibit 130, make very clear they track all of the movements of the defendant for about a for longer than that, but the relevant time of the 5-minute span. I think critically, and I don't disagree with my brother that the actual assault takes place right out of frame, but the lead up to it is more than sufficient that the defendant participated in the attack. He's seen milling around the Porsche limo on Connors at 2:04 a.m. That's on camera 7, and 2 minutes later, and this is where I think the crucial part is, 2 minutes later at 2:06:06. The defendant is seen walking up Connors to join the red and black attired group, the rest of the individuals in those tuxedo attire, rounding the corner to the right. You then see immediately after that, in the minute and a half that he's off screen and the rest of the group's off screen, you see other bystanders start to run up the street to
Can I ask
go
you,
over there.
With respect to the elements of aiding and abetting, right, what we used to call joint venture, participate in a meaningful way is one of those. And then there are a whole slew of ways that one can participate in a meaningful way. Do I understand that the Commonwealth theory rests on aiding and assisting, or are there multiple types of participation that you say a rational jury could infer beyond a reasonable doubt in light
It's
of the
both.
Commonwealth?
And so this pivots, thank you, Your Honor, to my second point here of the relevant testimony, and that would be the statements from witnesses that the whole group attacked the victim. And I think that the discrepancy here, or not discrepancy, but the distinction that my brother's trying to make is that this wasn't the whole group necessarily that started the night together, the 25 to 30 people who left the funeral in the limousines and went to the nightclub. But it was the whole group that at that point of the night approached the victim and his other friends and where the attack started. So you have Brian Jacobs, who testified that it was the whole group that moved in that direction, and that's on transcript volume 6, pages 116. At 133, he discusses how the whole group, that the individuals were taking turns going in and essentially having their moment with
And you're saying contextually whole group there is a subset of larger whole group?
Exactly. It could have been the larger group, but it certainly is sufficient for that the whole group that was at that place at that time was participating in this. So,
But how do you differentiate between mere presence? So, in other words, sure, the angle of the cameras at different times, the defendant, even by his own admission and in closing, the videos are being used, right, by both sides, that the defendant's in the area, for sure, and the defendant is seen there. But since the assault was off camera, how do you get beyond, sure, defendant was there, but what, because it's not like a whole group like, oh yes, X, Y, Z, and it's just like a whole mass of people taking turns and jumping in and getting, their chance to beat the victim in a crowded situation. We don't even know who that whole group may consist of the potentially 25 to 30 to 12 to 15, et cetera. But how do we get from, I'm with you that he was present, but that there's evidence that he did anything more than being present? Because I'm not sure a blanket statement of, yeah, all the tuxedo people or the whole group took their turn at him is sufficient for this defendant.
Thank you, Your Honor. I would disagree that it's not sufficient. Certainly, I would actually say that we have specific testimony from Joanna Pena placing the defendant in that group at the time. She describes the individual with braids when she jumped out of her car to assist the victim who she knew. So we have stronger evidence that he was in that group and in the core of it if she recognized him. We don't just have one witness saying the whole group. We have club patron, a third party, Miguel Soto, saying the whole group, and that's on volume 7 of the transcript. Omar Castillo, who was with the victim, described the interaction. So it's, I hear your Honor's point that we don't have anyone putting him, saying, I watched him kick the man. But here, and I would point the court to Commonwealth versus Dean, where the Commonwealth doesn't need to show how the participation took place.
Agreed on that, but the Commonwealth has to show that he did something. So is it leaving the jury to speculate that, now, maybe not the nicest thing to do, but maybe he ran with the group and just watched all of his friends beat this victim until it caused his death. I mean, how does the jury not speculate based upon that group, and he was in with that group, to saying, so what is the evidence he actually, besides being present, that he participated in some way? And I agree with you, doesn't have to show the fatal blow or a blow was struck. But what do you have?
Sure. I won't belabor the point about the whole group testimony. In addition to that, we have the blood stain that I know the panel has already spoken at depth about, that while the DNA did not come back to the victim, it's again strong evidence that the blood got on the defendant during.
Can you talk us through that strong evidence? Because to the point that there's no time frame, there's neither a quantity nor a temporal testimony. So I mean, I suppose it's unlikely, but I mean, people get blood in their pants and then maybe they didn't throw it in the washing machine, or maybe they threw it in and the blood didn't all come out.
It's further evidence that the defendant was so enmeshed within the group that the jury could infer that the blood got on him during this overall fight. And I would back up as well to the court's previous question about aiding and abetting, that here, even if, and I do not concede this point, even if the court is looking for another way to get there here, the defendant at minimum was present in a way that would embolden and encourage those who were making physical contact with the deceased.
So what in the testimony, what about his behavior encouraged or emboldened, which would be the aiding and assisting part, other than, and where do we draw the line then between someone who happens to be part of a group and stands and watches and then emboldens, unless there's actual testimony about behavior, facial expressions, gestures, words, something?
It's going to always be not circumstantial, excuse me. It's always going to be the totality of the circumstances and the facts and circumstances of this particular incident. I would cite to the fact that it was not just the victim and his group. There were 3 or 4 of his friends with him. So it's not just a 20-on-1 interaction. Having power and strength in numbers would embolden the group. But again, we have
How
direct...
specific testimony? Just work with me. Assume for the moment, take a second. Assume for the moment there were a group of 10 people and they all are charging around the corner, and then one guy just stops as soon as they hit the corner, and the other 9 jump and pile on someone and kick and beats someone to death. Without specific testimony, and you're just saying, so you're relying on whole group as opposed to, well, all but this one guy just stood there, but the rest of them all kicked him. You'd have to have something like that to kind of distinguish that person.
Where we're looking at the evidence in the light most favorable to the Commonwealth and the reasonable inferences coming from it, where we have more than one person, though one would be enough, where we have more than one person saying it was the whole group taking part in this. And I think, Your Honor, the fact that, going back to the video, it's from 2:06 to about 2:07:30, that's a whole minute and a half that the defendant remains off screen, remains with that melee before he is then seen coming back. So the suggestion, while the defendant was welcome to argue it to the jury, that he, per your hypothetical, froze when he turned the corner, it's less supported by the duration of time. But again, that would be viewing the evidence in the light most favorable to the defendant. So where we have the testimony that it was the whole group, where we have the blood stain, where we have the testimony in terms of identification that the defendant was the only person wearing a shirt like that night. And I would again refer the court back to Exhibit 130. It's incredibly distinctive seeing that white square on the footage. All of that together supported the reasonable, viewed in light most favorable to the Commonwealth, with the reasonable inferences that come from it, were sufficient to find participation and intent. And where those two come together, even the Commonwealth's case was sufficient.
I have some questions for you about how the evidence in this case differs from the evidence at the 2011 trial. As I understand the previous opinions of this court and the Supreme Judicial Court, those courts held that the evidence at the 2011 trial was sufficient to convict the defendant of involuntary manslaughter either as a principal or as a joint venturer. And it was based in part on the testimony in 2011 of the doorman, Joseph Serino, that the defendant was among the more aggressive of the participants, and that Serino picked the defendant out in a show-up outside the limousine afterwards. Now, at this trial, Mr. Serino testified that he picked someone out, but I couldn't find any testimony from a police officer that Serino picked out the defendant. Am I missing that in the record?
I don't believe so, Your Honor. I'm happy, I'll look at it after the argument, and if there is further clarity, I can provide that to the court. While there was certainly a different quantum of evidence in 2011, which was only 2 years after the incident took place, that doesn't diminish the Commonwealth showing here. So we do not have that testimony, but the Commonwealth still presented sufficient evidence for the jury to find.
Are you conceding that the evidence, although the evidence was sufficient at the 2011 trial to convict the defendant as a principal, the evidence is not sufficient here?
No, Your Honor, I'm not going to go that far. I think it's certainly where we don't have that specific piece of testimony. It's not, we didn't leap past the bar as far as we did in the first trial, but where the testimony of Brian Jacobs, that the whole group, and where he not only did he just say vaguely, the whole group was attacking Mr. Alicia, but he testified that he watched them go in, kind of take turns. So that depth of it, where he classifies it as the whole group, he's detailed about what that looked like, and then we have other witnesses who say the whole group, Mr. Soto. All of that together would be sufficient to find the defendant as the principal, but here we didn't need to prove principal. There for the aiding and abetting was sufficient enough, and the evidence certainly supports that when viewed in the light most favorable to the Commonwealth. And if there are no further questions, I will rest on my brief.
One kind of rhetorical question. How come you didn't file a 16L letter on Commonwealth versus Moscaratolo? It's a recent SJC case that talks about involuntary manslaughter standard.
I didn't make the connection to this case. I apologize for that, Your Honor.
Okay.
I'm happy. It sounds like it's on the court's radar, so I
We have it. We have it.
Thank you.
Thank you.
Thank you.
With that, we will take our morning recess. It is now 10:48, so we will be back at about 5 minutes past 11. Good morning. I will now call the next case, number 2025 P392, Margaret J. Reichenbach v. Timothy G. Haydock. Thank you.
Good morning, members of the panel, and may it please the court. My name is Melissa Allison. I'm here with my colleague Sean Grammel. We represent the appellants, Dr. Timothy Haydock and Barbara Moss, in this appeal. I'll begin with the judge's denial of the motion for a new trial. This is not a case about isolated harmless errors. This is a case where bias is evident in the record. It's demonstrated by the jury's finding on the accrual date, which is directly contrary to the evidence and plaintiff's own testimony. And it's demonstrated by the excessive and speculative damages award that resulted in an over $10 million judgment. First, to the accrual date. So for some context, the complaint was filed on October 1st, 2015, so the claims each have a 3-year statute of limitations. The vast majority of trial involved events that occurred more than 3 years before the complaint was filed. For each count and for each defendant, the verdict slip asked the jury to determine when plaintiffs, and this is a quote, first knew or reasonably should have known that they were harmed by the defendant's conduct, and to check on the verdict slip whether that was before October 1st, 2012, or on or after October 1st, 2012. For both counts and for both defendants, the jury marked on or after October 1st, 2012. That finding is contrary to plaintiff's own testimony and the testimony of other witnesses. The cites to the record are on pages 59 to 61 of our opening brief, but I do think it's important to go back to the plaintiff's own words about their knowledge. The centerpiece of the plaintiff's claim against Ms. Moss were threats that Ms. Moss allegedly made shortly before and during a permitting appeals in 2011. So Ms. Reichenbach testified to an alleged threat in January 2011 and said that after that threat, quote, all the delays really started to become huge. She also said at that point that Ms. Moss began to intimidate workers. She also said that after that threat in 2011, she started having nightmares up to 3 times a week. Mr. Reichenbach claimed that Ms. Moss threatened him multiple times from December 2012 through June 2011. He went on to testify that by the beginning of 2011, he viewed, quote, all of the defendant's actions as pretext. And he testified that after these alleged threats in 2010 and 2011, that he felt coerced, harassed, and trapped as a result of the delays at the site. And he
So are you arguing that we should deem the plaintiff's testimony not credible?
No, I'm arguing that the testimony is directly contrary to the jury's verdict, that the plaintiffs did not know. We don't need to talk about should have known. The testimony is that they knew both of the claimed tortious conduct and the effects long before October 1st, 2012. Their own testimony establishes that, as well as the testimony throughout trial about the alleged interference and the alleged delays as a result that happened all through 2011 and early 2012.
But can I ask you this? Isn't that why we leave that to the jury? So, in other words, this was a lengthy trial with a lot of evidence, and there wasn't a specific incident in which all parties agree, this is the date that I knew what happened. Instead, in the beginning, it was all neighbors, right, that were coming together and trying to resolve disagreements about how the new house should be built, et cetera. And it wasn't until, like much of trial, hindsight, that they look back after all these series of events and say, started feeling it here, started feeling it there, then this turned and that turned. And don't we leave that in the hands of the jury to determine, based upon all of the evidence, when they knew or should have reasonably known?
Well, the jury should look at all of the evidence, but here the question is when plaintiffs knew, not what they could have thought. And this is where the judge and the plaintiffs here err in their analysis. It's not what could they have concluded from all of the evidence. We don't need to ask that because the plaintiffs told us what they believed at trial repeatedly. They repeatedly said that they believed that they had been threatened, coerced, harassed as in the early 2011, right? And that they began suffering what they claimed were their damages at that time.
And I understand your argument, but how do we know, since we weren't in jury deliberations, if the juries said it really wasn't then, even though they thought, right? They said they knew. It's actually right here, this other event, right? It didn't happen until after October of 2012 because there were a series of events that were ongoing. And so, again, how do we know that the jury didn't thoughtfully consider all the evidence and say, despite what they now testify, it wasn't until right here and then?
Well, the judge addresses this point and in the decision, and I think the problem with that suggestion is that if the jury, in fact, didn't believe that these things had happened or didn't affect the Reichenbachs in the way that they claimed, then they're essentially saying that they didn't credit the Reichenbach's testimony yet awarded them millions of dollars of damages. That's just inconsistent. And on top of that, you know, it is we're talking here about, we've got other indicators here of prejudice and error, right? We've got the excessive and speculative punitive damages award. We have the judge's errors that caused irreparable harm to Ms. Moss's credibility with respect to the spoliation questions and the damaging closing argument. When you look at all of those things as a whole, looking at the trial as a whole, and then you add to that a jury finding that is directly contrary to what came out of the plaintiff's own mouths repeatedly at trial, I think it raises the real specter that that jury finding was not based on reason, right? It was based on bias. And so we are looking at all of this as a whole.
Can I ask you what you think, because you do present numerous issues on appeal. What's your strongest argument of all of these?
I think the combination of the accrual date and the damages award, which in our view, actually show you the prejudice, right? I mean, this is understandably, this is the tricky part often of, an appeal is like you point to particular errors, even ones that seem really significant, but you ask, well, at the end of the day, did that prejudice the jury? What we have here is demonstrable evidence or proof in the record that the jury was biased as opposed to reasoned. I mean, when you add that accrual determination, contrary to what the plaintiffs were saying, and the speculative and excessive damages award, I think that's the primary focus.
So can we talk about damages for a moment?
Yes,
because the home initially was estimated to be costing about $4 to $5 million, correct? To be built?
That was some testimony, yes.
And eventually it was $10 million.
Yes.
That cost. And
total costs.
Total costs. And so your argument is that in certain instances, for example, the harm to the plaintiffs and the intimidation, that there wasn't enough documentation from psychiatrists or psychologists or harm, or because there were areas in which the plaintiff didn't put a number, right? They argued that they were harmed, period, and others, they provided the jury with consideration of invoices and expenses and burdens, for example, an environmental lawyer, et cetera. So where in those damages is it so off-putting to you that it's against the weight of the evidence, or so as to be speculative?
Yeah, so with respect to the out-of-pocket cost type damages, those weren't consistent with any piece of documentary evidence, and I'll go into why in a moment. With respect to the other sorts of damages, emotional distress, loss of use, there was zero evidence in the record other than testimony, and that what amounted to about $1 million of damages of that sort far exceeded what the testimony would support, right? Even by the generous standard that applies. So let me just go through very quickly. I understand there's a lot there on the verdict or the special interrogatories. And just so you know, you've probably looked at them, but it's volume 1, pages 193 to 199, which is the verdict slip and the special interrogatories. So the key is here, the damages awards on the out-of-pocket costs exceeded even what the plaintiffs were arguing as for their damages, as opposed, much less what the evidence showed. So at closing argument, plaintiffs pegged their intentional interference damages, out-of-pocket costs, at about $750,000. Their own argument was based on the builder's testimony that number was, quote, his best guess at his excess costs. That was speculative to begin with, because as we lay out in our motion, this is on opening brief, pages 71 to 78, that was not based on any documents in the record. He had no schedule at the outset, no budget at the outset. He didn't keep any daily logs. There was no evidence in the record to indicate that anything that the defendants did actually resulted in any of those excess costs for him to manage the site. So the trial judge's decision on didn't even grapple with any of those inconsistencies. The trial judge looked at one thing that John Reichenbach said at the outset of trial, that it cost, what Justice Walsh referred to, that, well, it cost me $2 million more total. So to begin with, that total doesn't even reflect the intentional interference damages. He was referring to the total. So the judge's reliance on that for the intentional interference damages was contrary to Mr. Reichenbach's testimony. It was contrary to their contractor's testimony. And all of that testimony was speculative to begin with. Now, turning to the MCRA damages, there at trial, the jury awarded $1.5 million for those damages. $1 million of that was out of pocket, $500,000 was for emotional distress. In closing argument, the plaintiffs pegged $670,000 as their permitting damages under the MCRA. Much of that was again based on speculation. You know, contractors saying, well, I would put it at approximately X, like 3 or 4 years after the fact, as opposed to any documents in the record. That's at pages 66 to 67 of our brief. And even if the jury accepted that entire amount, that entire $760,000, that would leave $330,000 for loss of use based on a claimed 1-year delay. There was no economic proof for that, and the trial judge explicitly instructed the jury, and this is at volume 5, 382, that loss of use was not an economic claim because there was no evidence that the plaintiffs were going to rent it out. And then, so again, just looking at what's left, we've got another $500,000 on MCRA for emotional distress, plus $200,000 already awarded under trespass for emotional distress. Also non-economic, based on things like, you know, nightmares and insomnia and anxiety, never sought medical attention, never had any medical costs. So when you add those non-economic damages for loss of use and emotional distress, you're talking about $1 million in non-economic damages on top of the unsupported and speculative out-of-pocket costs. So whichever way you cut the numbers, that is a punitive award. It's not supported by the evidence. And I want to briefly address the 2 errors by the trial judge that we think contributed to this demonstrated prejudice in the jury's findings. So the trial judge repeatedly permitted counsel to ask Ms. Moss about spoliated evidence, even though he found no evidence. He concluded that no evidence was spoliated and that there was no prejudice to the plaintiffs as a result. Yet he still allowed the plaintiffs to ask questions about these theoretical missing photographs, and he allowed plaintiffs to ask questions. Some he sustained, but many he allowed questions about, you know, well, what else might have been on your computer, and what happened to those documents?
Can I interrupt for a moment? Because your briefs, both sides, are excellent and very thorough, but there's only 43 seconds left. Why isn't the closing argument issue waived when there was no objection to the curative instruction?
There was an objection to the curative instructions, but to begin, the Fife case, which is cited in our papers, finds that even where no objection is made, improper closing arguments are always reviewed, at least for plain error. But here, defense counsel raised numerous objections. They're excised from plaintiff's brief. You can find them, we refer to them in our brief. You can find the entire discussion with the judge about the curative instructions at volume 4, 368 to 372. I raised numerous curative instructions that the judge declined to accept, specific things that he declined to accept. In fact, he recognized that some of the statements were improper and said that he did not want to call them out or highlight them or use the same words, but effectively ended up giving general instructions as opposed to any of the curative ones. Now, I wasn't required in this, Mass Rule of Evidence, or Mass Rule of Civil Procedure 51B, the SJC's recent case in Tensar. You can look at any of those to find that you're not required to keep raising futile objections once the judge is on notice of your objections. Here, he was clearly on notice. I see that I only have less than a minute left.
Negative.
Other way around here.
Oh, you're right. It's red. All right. Well, with that, I will rest on our papers for the
Thank you.
JNOV.
Thank you.
Thank you.
Good morning. Good morning, Your Honors, and may it please the Court. Kevin Powers for John and Margaret Lynn Reichenbach. John Reichenbach is here in court today, and Lynn Reichenbach was unable to be here for medical reasons. With me today and with me on the brief are attorneys Robert Feingold, Heather Bonet-Hebert, and Brian Fielding. Your Honors, this court has seen this case before. 9 years ago, this court issued an ominous prophecy of what would almost inevitably happen if this case were to go to trial. In 2 extensive footnotes in Reichenbach 1, this court spelled out the implications of what would happen if the Reichenbachs were to prove the allegations in their complaint. Well, the case did go to trial. And after 15 days, 5 weeks, 19 witnesses, 181 exhibits, the Reichenbachs proved each of those allegations. Charts 1 and 2 in our addendum set out the evidence proving each of the allegations, correlating the one to the other. And years after the defendants stated that we will torture them, just you wait and see, the jury returned a just verdict. Your Honors, my sister discussed several arguments, and I'm glad to address each of those in turn. Briefly, I believe that I'm starting where she started. As to the statute of limitations and the accrual date, this is a classic issue for the jury to pass on, as Justice Walsh noted. Further, I note that Defendant Moss, in her testimony, outright denied that the January 2011 threats ever took place, and that if they ever did take place, she insisted that they were nothing like Lynn Reichenbach characterized them. As to the other evidence and the other dates on which things happened, my sister is cherry picking. And we spell this out in our brief as we do our other arguments. I can only say so much in 15 minutes, but just to hit a few of the high points. The defendant's second round of sham petitioning started in the summer of 2013, well after the October 1st, 2012 key date. But beyond that, and a particularly profound and significant fact about the difference between that petitioning, that sham petitioning, and the prior sham petitioning, is that it was only as of the 2013 petitioning that the group of 10, pretense or artifice, finally completely fell away. And now, the only parties to these sham petitions were finally exposed to be Defendant Haydock and Defendant Moss. Prior to that time, the defendants worked overtime to try to erect this facade of a group of 10 folks in the neighborhood who had concerns and were worried about this and worried about that and that kind of thing. It wasn't until 2013 that they were fully exposed for really and truly operating alone. Beyond that, I note that the extraordinarily hostile emails from the defendants did not come out until discovery in this case. So during the entire time that both the sham petitioning and the on-site at the construction site harassment was going on, the Reichenbachs were completely unaware of any of those emails and the clarifying nature that they conveyed and that they made clear at trial. Further, I note other occurrences, all of which were well after October of 2012. Defendant Haydock approaching hostilely general contractor Lars Olson at the deck where Olson was building or rather working on the Reichenbach's pool. And had about 10 other workers and subcontractors around him, and threatened Olson, cursed out Olson, cursed out the Reichenbachs, threatened to shut this down, threatened that the Reichenbachs had no right to build this and so forth. That was after October 2012. The nighttime trespass, where the non-quit security guard caught Defendant Moss running back from the Reichenbach's house after dark in the middle of February 2014, as Defendant Haydock was waiting in the getaway car. That was well after October of 2012. The defendant's abuse of the FEMA LOMAR process to attack the Reichenbach's finished basement was after October of 2012. The bottom line, fundamentally, Your Honors, is that the defendants worked actively, consistently, and ardently for years to conceal and deny their true improper coercive motive and means. Put simply, they hid their goals and they hid their roles. And it's not the Reichenbach's fault that, like any good citizens or any good neighbors, they did not assume the worst immediately of the defendants and did not leap to race into court at the first possible untoward conversation, but rather only after it had truly become clear what was really going on did they file suit.
Attorney Powers, without getting ahead of ourselves, and feel free to circle back, and without in any way suggesting anything about where I think I might come down on this, could you just address your request for attorney's fees and costs on the appeal?
Yes, Your Honor. Your Honor, we have...
It's a little unusual for us, but I understand what you're saying here is this is an unusual case, so.
Certainly, Your Honor. Your Honor, we make our request in the form of, to use the colloquialism, belt and suspenders. The belt is the MCRA, which entitles us to fee shifting. The suspenders, out of an abundance of caution, because that tends to be the way that I like to write briefs, is the frivolousness of the appeal under Mass Rule of Appellate Procedure 25.
Did the trial judge award attorney's fees under the MCRA?
Yes.
Do you have a record site for that?
I can certainly send a 16L letter. But
It's in there, because it's in the amount of about $2.3 million, isn't it?
I believe so, but I know that as yet another indication of the reasoned and careful approach of this judge, I believe that the amount that the judge ultimately awarded in counsel fees was something in the range, and I may be mathematically a little imprecise here, but it was something in the range of, forgive me please, it was something in the range of about 50% of
I just have to have 4 lawyers. There you go.
of the request. Certainly, Your Honor. And so again, I believe there's a point in my sister's brief in which, through a turn of phrase, one might have inadvertently gotten the mistaken impression that the judge simply signed off on all of the counsel fees that the Reichenbachs were requesting. No such thing. The judge cut them down dramatically, and again, I would highlight that as yet another example of this judge trying to be fair, reasonable, equitable, and thoughtful throughout the process. Now, as to my sister's argument about the damages. They make a lot of arguments about damages. I'll make one point, maybe 2 right off the bat. And I'm glad to clarify other aspects. But just 2 initial thoughts as far as damages go. First, as far as my sister during argument made various references to various individuals testifying as to numbers. It should not be lost on this court that the jury had before it, both in paper form and I believe in a clean laptop that had all of the documentation, something in the ballpark of 5,000 or more pages of billing records, not just from Lars Olson, but from numerous other contractors and subcontractors, and whether it were the various engineering, coastal engineering firms that the Reichenbachs had to hire to deal with these sham issues that the defendants were raising in their sham petitioning, whether it were the billing records and summaries of billing records from the environmental attorney. That was the attorney who testified over Zoom at trial. Whether it were records, I believe, from the architect. Numerous. I list only a few now, but I could go on. I believe that most of those are in exhibits numbered 120 and change and 130 and change. I may be slightly off there, but they are voluminous, and I believe that all or nearly all of them are included in the record appendix. In addition, Your Honors, if you take John Reichenbach's $2 million summary figure, if you take that and hold it on the one hand, and then if you take the numbers that Lars Olson and the various other subcontractors, and the environmental attorney, and the various costs of other contractors, subcontractors, the costs of the concrete, massive, enormous concrete pillars that the security cameras had to be installed in, the cost of planting super weighted boundary stakes because the defendants kept pulling them out of the ground overnight and that sort of thing. If you take all of the all of the various enumerated costs, and we set out those various costs in the discussion in our brief about damages, those add up to about $2 million. And to the extent that if there's any difference in the nature of, say, $10 million, I'm sorry, beg your pardon, $10,000 or something like that, if there is like a 1% difference or something to that effect, that's easily completed under 766A, when we recall that 766A is to compensate not only for excess cost, but also for excess burden, and the burden to which the Reichenbachs were put. Not just having to hire all of these folks and to purchase all of this additional equipment for the site, but to spend all of the time dealing with all of these with all of these sham petitions, having additional weekly and even more frequently than weekly meetings with Olson and the rest of the team and so forth. The increased burden would certainly complete whatever 1% difference there may be. For example, if by aggregating the various figures we were to reach about 1,900,080 980,000. Then that final 20,000 plus is easily met with the extra burden. I see that my time is up.
Thank you.
Your Honors, I ask only in closing that this court recall that our brief is very comprehensive. I can't say in 15 minutes what we said in the brief, but it's there.
We'll have to leave it there. Thank you.
Thank you very much, Your Honor.
So we will call the next case. It's number 2025-P713, TEH versus CR. I would remind the parties in this case that the case is impounded, and so to the extent possible, please refer to the people by their relationship to each other and not by name. So I understand the appellants are splitting their time. And Ms. Krasner, for the child, you have 13 minutes, and Ms. Bierwas, for the putative grandparents, you have 2 minutes.
Good morning, and may it please the court. I'm Sherry Krasner, here on behalf of the now 9-year-old appellant child, together with the other appellants, and because it's an impounded case, I will refer to them as W and T. We request that this court reverse and vacate the judgment and remand the matter back to the trial court so that a visitation order can enter. This is the only proper remedy for the harm that my client suffered, for the seismic disruption in her life that resulted from her mother's actions, actions that the judge herself called reprehensible, selfish, and not in the child's best interest.
Attorney Krasner, can I ask you if you took out the guardianship and all you had was the equity, the de facto parentage question, and I'm going to call them grandparents instead of putative grandparents, and the grandparents decided not to appeal the judge's decision, is it your position that you, on behalf of the child, had an independent right, had standing to file an appeal?
Yes, the child was harmed.
And how is this different than, for example, if you had a couple of fit parents who might be reprehensible and horrible and do all sorts of things during a litigation that are horrible for the child, and the judge makes a decision, and the child has a GAL, right, in that situation? Do you think the child has a right, the 9-year-old child has a right to appeal that decision by a judge?
Through the GAL, I believe that the child would have.
Child has standing to appeal the visitation, a 9-year-old child, between two fit parents?
No one is,
Do you have any authority for that proposition? Because I looked and I couldn't find anything. Do you understand what I'm?
I would just suggest that the probate court, because of the broad equity powers that the probate court has, that the court had the authority to appoint counsel in this case and in other cases.
And we appoint GALs all the time in the lower courts. That doesn't necessarily give the GAL standing to appeal if they're not a party, an actual party to the case.
But the probate courts do also appoint the ARC program, the attorney representing clients. The probate courts do appoint counsel for children, not in every contested removal
But
case.
does the appointment of counsel make the child a party?
I think what makes the child a party is the harm that the child suffered, and in this case, and this a de facto case, it's all about the harm to the child. It's all about protecting the child's interests by, in the absence of an order. And,
Can you allow, though, so if we agree with you, we're carving out some new case law on this? This is not, again, or is there a case that says that, again, the child of, in this case, because there's only one fit parent in an equity proceeding where they are not an actual named party, is vested with appellate rights, certainly simply by having an attorney appointed for them?
well, I just keep coming back to that. This case is all about the child, and does an order need to enter to protect the interests of the child? And if that's what the case is about, I don't...
But this happens not infrequently, I would imagine, that there's some issue and an attorney is appointed to represent a child. And I can't find a case where the child, again, and I'm just using a divorce proceeding because it seems to be the most comparable, where there's issues about visitation, and you have two parents, and the child doesn't like the fact that they have to actually now spend more time with the mother as opposed to the father. Does the child get to appeal to us, to the appellate court, and say, or to the SJC, and say, well, even though I'm not a party, even though it's a divorce between my parents, I have appellate rights because I don't like the amount of time I'm assigned with dad versus mom?
I don't disagree, Your Honor, that I could also not find a case, but I also would say that the fact that programs like the ARC program exist in the probate courts, where the probate court judges have the discretion, not in every case, but they have that ability to appoint an attorney for the child, that they have recognized that their broad equity powers give them the ability to appoint an attorney to represent that child's interests and to appeal on behalf of that child. And I think it's this child, she was harmed by the absence of an order. And I think in this case, why you need to reverse and vacate the judgment is because I'm not here saying the judge made a handful of findings that were clearly erroneous. I'm not here saying she didn't weigh the testimony of one witness correct. I mean, those are uphill battles that appellants often take and more often than not lose. This is a case where the judge committed a clear error of law. She relied on one cherry-picked sentence out of the Yeomans versus Ramos case, and that is, it's at 429 Mass 782, where she said, where the case law says, there was uncontested, overwhelming evidence that with the acquiescence of the father, a substantial mother-daughter relationship had developed between Tamika and her aunt. And what the judge here did is she took that one sort of sentence out of context, and she said that that meant that a de facto relationship existed in Yeomans because, and only because, there was uncontested and overwhelming evidence of the legal parents' affirmative agreement to the relationship.
So how do we second-guess the judge's fact-finding that this mother did not consent?
What the judge, because the premise on which the judge relied was that it had to be this uncontested, uncontroverted, ironclad consent to the formation of the relationship.
So the judge talks about the definition of de facto parent, or the proof requirements and cites to ENO versus LMM, and you sure know better than I what those are. And then the judge finds that there must be sufficient and credible evidence that the mother consented to the de facto parent relationship, and then ultimately finds that I cannot find that the mother provided unequivocal consent to the formation of the de facto parental relationship. Why is that not enough, that finding?
Because she misconstrued what Yeoman said. She said that Yeoman says it has to be this ironclad,
She said
uncontroverted.
unequivocal. So the question is, if it's not unequivocal, what is the appropriate degree of consent? What is the appropriate adjective, if any? How do we, is it free consent, freely consented? Is it willingly? Is it knowingly? Is it, I mean, in the world of consent that we deal with, there are always qualifiers.
Right, and in...
What is it here?
I think we look to what the parties did. I mean, what...
But the mother is giving up her constitutional right as a parent.
Absolutely not. We're not suggesting at all that's what this mother did or that's what this court should find. She was a fit parents can, there can be intrusions on the fit parents' ability. I mean, that's what the Blix case stands for. And even in Yeoman's, there's language that says that the father was fit. It's not an issue of a parent not being fit.
But Yeoman's was a different situation, right? I mean, here, it seems to me the bigger problem is that you can't go through the grandparent statute, because by going through the grandparent statute, they put the son in jeopardy of being prosecuted for stat rape, for which I believe the statute of limitations expires in about a year. I may be wrong, but it's a 10-year statute of limitations, right?
I don't practice criminal law. I'm not going to address that question.
On that
but this mother knew where this child was every single night for those 5 years.
So can you just define, so the error of law that you're suggesting that we find, assuming that the child has an independent right to appeal, is that the judge mistakenly held the standard to unequivocal consent and thereby mistakenly created a higher standard of proof than what was required, so that if it was just plain consent without the word unequivocal, that there is adequate evidence in the record to support the judge's finding that, in fact, mother did consent to the child being cared for by the grandparents for that period of time.
That's exactly right. You framed it exactly as I see it. I mean, and this is what the judge says. In this case, the court cannot conclude that mother's consent and encouragement of this arrangement was as unequivocal and uncontested. But again, and then she stops her analysis. She doesn't think about the harm to the child, even though she concedes that the child was harmed.
Right, but we don't even get to the harm analysis. We have to focus on whether the consent was given to allow the grandparents to step in this way.
Correct.
And so if the standard is here, but she held it to be higher, and you're saying they've shown, and the judge has acknowledged through her findings of fact, that the evidence supports this was a consensual caring of the child by the grandparents. It wasn't 100%, right? It wasn't, nobody disagrees, but there was sufficient evidence for the judge to find consent.
Right. She applied the error of law. She applied the wrong standard. She said it had to be so ironclad and unequivocal.
In fairness, I think you're using words, you're putting words in the judge's mouth that she didn't use while
She
accusing
didn't
her of
say
using the wrong
ironclad,
words. She didn't say ironclad.
That is how that's my gloss on it.
No, but let's use the words used. I think the words are critical here, right? So the actual word is, and the only place where it seems to me it states a legal standard is unequivocal consent. The part about consent and encouragement was unequivocal and uncontested. That's actually slightly different, because that's just using it as a comparison and saying it was not as unequivocal and uncontested as Eunice or Ioannis versus Ramos. So that seems to me is slightly different, but she clearly states that the legal standard is unequivocal consent, and that's what you're saying is an error of law.
Correct.
Clear?
And she also relies on guardianship of Estelle, which isn't even a de facto parenting case. It's a case in which the court said, that was a guardianship case, and the court said if this goes back, you might want to consider whether a de facto parenting relationship existed. And again, our judge, cherry picks out of that because the father in Estelle said that there was language that he was perfectly willing to agree to the arrangement that existed with these de facto caretakers. And again, she takes perfectly willing to have some sort of legal significance. And again, it wasn't even a de facto case, and it also
I have a question for you about a case that you didn't cite, but you probably are familiar with it, which is guardianship of KN, where the SJC held that a parent in a guardianship case has a right to counsel. And there's a footnote in there where the SJC acknowledges that the mother is arguing that the child doesn't have standing to bring the appeal because the child was really asserting the rights of the guardian. And the SJC said, we acknowledge that argument, but we're going to reach the issue of the parent's right to counsel because it's one of importance and it's capable of repetition of evading review. Can we do that as an intermediate appellate court and say, even though the child wasn't a party to this de facto parenting case, that we can let her have this appeal?
Well, she was a party.
By virtue of having counsel appointed.
Correct. And again, I keep coming back to that unlike in a guardianship case, in a de facto case, when you're reaching the critical issue, it's the harm to the child. You have to look at the child.
So there's various other kinds of cases, and I know you're not a criminal lawyer, but say a crime victim has a statutory right to be heard at sentencing. And there may be situations where that crime victim is represented by counsel, paid for by themselves probably. Does that make them a party to the case?
Again, I have to say, I don't know anything about the criminal law, but I just keep coming back to what is this case about? I mean, and to acknowledge that it's not, from my client's perspective, these grandparents were her de facto parents.
But I guess my question is, if the parent is fit, why do we get to the best interest of the child? And I have a hypothetical to ask you. Let's assume there's a child whose parent wants them to go to the local public school, and the proposed de facto parents say, no, this child should go to boarding school, and we'll pay for it. And at this fancy boarding school, she'll get to ride horses. And the child loves riding horses and wants to go to the fancy boarding school. Why do we get to the issue of whether or not it's in the best interest of the child to go to the fancy boarding school if the parent is fit and wants the child to go to the local public school?
I think in these cases, you look at how much of an intrusion it is on the rights of a presumptively fit parent. I'm not trying to take anything away from a presumptively fit parent, but I'm saying it's always a balancing act, and there may be times where a carefully crafted order that doesn't intrude as much onto the rights of the parent that may be necessary. And I think the Blixt case on grandparent visitation, I think that case talks about that balance between a parent who's presumptively fit, no one's trying to take away their right to family integrity, but that it's necessary in some cases to make a carefully crafted intrusion into that right.
Thank you.
I say I'm well over my time, and I thank the court.
Thank you.
May it please the court, Catherine Bierwas on behalf of Tim and Wendy, who are present in the courtroom today. I intended to discuss the motion to dismiss and the
Please,
issue.
because I just, I'm glad you did, because I
Okay.
just talked me around the hard one-year deadline.
Okay.
Please.
So September 6th, 2024, my office filed the timely notice of appeal, but it was docketed in the wrong, matter. It was docketed under the guardianship instead of the de facto. On June 18th, this court made us aware that you didn't have the notice. We figured out what happened. We went to the court. They said, okay, you need to file a motion. Judge needs to hear it. She needs to allow the correction. So we did that, and on July 14th, Judge Doyle allowed the motion. July 24th, the appeals court said you needed to show cause, why jurisdiction was still valid. We filed an affidavit that was accepted as an affidavit for a late appeal.
And then Judge Shin said you need to
August
refile
1st.
the notice of appeal by August 8th.
By August 8th.
And I think she probably picked that date because that was when a year expired. Did you file a notice of appeal by August 8th?
Yes, we actually filed it on August 1st, and I have proof of that. It wasn't until this weekend that I was able to tease out where exactly it happened. So we filed the notice with the lower court on, on August 1st, and it's an equity matter, so you can't e-file. It has to be done over the counter, which it was. It was done over the counter, and we heard nothing, and we couldn't check the docket again because it's not on the e-filing. On September...
Where is that in the record, the notice of appeal that was filed on August 1st?
It's not, and I can explain, and
You would have saved me a lot of time this weekend.
I have emails from
So-
the court. I did spend time trying to
Okay.
figure and tease all of
Trying to
this
do a
out.
timeline here and figure out if there's any way around the one-year cutoff, where under
So I
Rule
have-
14B, it's kind of hard deadline.
And I have here a copy of what was filed on August 1st.
In the
with
probate and family court.
In probate and family court, with an email from the clerk who said that the office is in receipt of the petitioner's notice of appeal filed on August 5th, that's when they accepted it, wherein you made a handwritten change to the docket number in the heading document by crossing out one number and writing in the docket number. We are accepting this as to the filing date only. Please file a corrected petitioner's notice of appeal with the corrected case name in the heading. It said it also had the guardianship case name in the heading, so it wasn't just the docket
Why
number.
isn't that document in the record appendix?
It should have been, but apparently it was never, ever put on the docket. I do
So
have...
where is it? Is it in the probate and family court registrar's office? Is it just
It's
on a bulletin board somewhere or in a?
I have no idea where they have it, but I do have proof that it was received by them. And I also have an email from the judicial case manager because within moments of 21 minutes of receiving that email, which again was September 16th, we sent over to the judicial case manager a corrected copy, and she said, yes, except include, quote, indicate that it was, quote, originally dated 9/6/24, corrected 9/16/25, nunc pro tunc to 9/5, which
Well,
was
I've
an
seen that
error.
one, the 916 nunc pro tunc, which I'm not sure that they can do to circumvent the single justice order, to be
Okay.
honest with you. But so the 9/17/25, that's when the grandparents filed their notice of appeal.
That was the second one, and I have the emails, and I can
There's one that was,
supplement the record,
well,
and I
make you
have,
feel better
and I
about
have the
scheduling.
original filing.
The problem is that the appellate record consists of the papers on file in the trial court.
But you can't control the docketing, and so if you filed, I'm just going to put it out there, if you filed under the deadline, you can't be held responsible for somebody who's working in a court who either is unaware or doesn't properly docket your filing. And so while I'm looking at all this aftermath and nunc pro tunc of a single justice, I think that's going to be a very tough mountain to ever climb. But if you did what you were supposed to do, which was under the one-year deadline,
Yes.
submit it, and it's only in a file and not in e-filing, not in a docket, but it's there. I don't know what more you could do to perfect an appeal.
I do have to say, and I accept full responsibility for our response not including that, because it should have been included in our response. And for that, I accept responsibility, but we did.
Can I just understand, how long have you known about that?
Saturday.
What you have in your hand? Just Saturday? Oh, all
I-
right, that's why you couldn't put it in your response, I suppose, because,
Right.
you know, all right.
So how long have the appellees known about it?
Now?
They were,
I feel like I'm back in district court, this is great.
my understanding is that
sorry.
they were served and they agreed with the original
Okay.
filing from the wrong docket into the corrected docket. And
But when you just say today, on August 1st, when you filed that, didn't you CC?
according to the certificate of service, they did. They were served with it.
And not, you know,
Yeah.
But it sounds as like you're saying on August 1st or.
August 1st, it was submitted, according to the email that the court gave us, they accepted it as of August 5th.
But did somebody on August 1st go into the court and write on the docket, cross out the docket number?
They
Or did
brought
they
it-
submit a new piece of paper with the docket number crossed out?
Yes, they submitted the original, they downloaded the original, and because it was just a Scrivener's error, they put the
And
corrected docket number
So did they
here.
serve that on the opposing party?
I believe they did. According to her certificate of service, it was my.
Okay.
It makes
the
me feel
attorney.
better, because I kept saying all weekend, why wouldn't someone just, as soon as Judge Shin gives the order, cross out the number, stick a new number on there, and then file it?
That's
'Cause how
exactly
simple
what
is that? Why
happened.
would
The
you wait a
same day
month
we were
to do
told to
that?
do it.
Ah, well, there you
So,
go.
I have a question for you about the grandparents,
Yes.
for sake of argument, call them that. Seeking visitation under this de facto parentage.
Yes.
Ordinarily, when there's a visitation issue, it's between two parties, parents who have been in a romantic relationship of some kind and they're divorced. This mother has never been in a romantic relationship with the two grandparents.
That's correct.
Let's say a court were to give your clients what they want and they were to get visitation. And then, do they get to just say, well, we want the child on Mother's Day, or we want the child on her birthday, or, we want her on Halloween?
No, I don't think they do. I think that it's the court orders, just like they would in a probate matter, in a family court matter.
We'd have
a
to remand this
visitation
on
issue.
this. We'd have
I'm
to
sorry.
remand it. I assume we'd have to remand it for the probate court to sort through all this.
To issue, I would ask that you remand it for them to set a schedule, not remand it for the decision, because I do agree with co-counsel that it was absolutely, all of her findings supported the fact that they are de facto parents for 5 years, including the fact that the child had only spent maybe one day the entire 5 years away from them.
can I just, and this isn't directed toward you, it's directed really in general. I think the probate and family court judge made it crystal clear about the tragedy of this case, that everyone can see. Very important legal issues, but on a human level,
Yep,
the
I agree.
absolute tragedy of this case, and encouraged all parties to take a good hard look at their behavior and the consequences it has on the child. And so I hope that that message doesn't go unheeded. Obviously, we'll deal with the appellate issues that are before us, but it bears being reminded to all
And
parties.
I think that's where we were when they were met with DCF, when DCF tried to intervene and help come up with a solution, and they did come up with a parenting plan that was going to last them at least a few weeks.
I know we're way over time, but if I'm not mistaken, the mother's brief seems to suggest that they've gone along with that and given visitation in accordance with the plan. Sorry, my read of the mother's brief is that since that time, there actually has been visitation that has been consistent with the proposed or the informal visitation plan. Is that not correct?
I would say that it is a far cry from anything that it was, and it is, I don't know if your honors want me to say what it is, but
It's not
it's
on the
very,
record, but
it's,
I'm just saying that's what they claim in their brief, and I didn't see anything to the contrary.
and I would feel that's slightly disingenuous.
Okay.
Thank you.
Okay, thank you.
Well, just give us 1 second.
Good morning, Your Honors. May it please the Court, my name is Christina Paradiso, and I, along with my colleagues Francie Gazzaniga and Brittany Noto, represent the mother in this matter. I want to state at the outset of this case what it is not. It is not a care and protection case, it is not an adoption case, and it is not a guardianship action. In other words, mother's fitness is not and was not on trial. Instead, this case is an example of a social dispute that the petitioners are now trying to cram into a legal box into which it simply does not and cannot fit.
Before we get into substance, because I'm not sure that we thought we knew we were going to have to deal with the substance here, but do you have a position on what was apparently just handed to you? Because it does seemingly knock out a rather important issue, which is that we really didn't have, I don't know if it's authority or jurisdiction or however you want to phrase it, but to even address the issues because it was outside the 1 year time, and unless we find that the child independently has standing, which I'm not sure we're at, but, you know.
Yes.
But on the other hand, you don't want, I mean, if they did it, you don't want to hold it against them because someone in some clerk's office somewhere apparently didn't.
Yes. While we
Docket it.
don't think, and I did a brief review at council table, we do not think that we ever received notice that the proper notice of appeal had been timely filed. I can't gainsay what my sister council presented today. I simply don't know.
Okay. Why don't we handle it this way, and counsel for the grandparents after this oral argument can file a motion to expand the record to include that document with service to all parties, and you can have an opportunity to search your files and possibly discuss it with the probate and family court, obviously supported by an affidavit explaining where it came from, and you'll all have an opportunity to determine whether or not it was filed timely.
Yes, Your Honor. Assuming that it was not timely filed, as I walked in today, assuming that it was not timely filed, I would like to remind the court that there are very clear jurisdictional requirements that attach to the 1 year time frame. And the leading case that I could find on that is the DeLucia versus Kafori case. And that case says very clearly, a timely notice of appeal is a jurisdictional prerequisite to our authority to consider any matter on appeal. And I would suggest that sets the standard, and grandparents have not met that jurisdictional standard to allow their case to be considered today.
Turning to the substance, do you agree that the judge applied, in her applying the standard for de facto parentage, unequivocal consent of the mother? Do you agree that that was not just a passing phrase, but that was actually what she thought was the standard, whether it was or was not?
No, I do not.
Okay.
And it may have been an unfortunate turn of phrase that seems to have taken on a lot of significance that it simply doesn't have. Because when we're looking at the standard to become a de facto parent, the heart of that is there has to be a parent-child relationship. And here, there was no evidence ever presented that there was a parent-child relationship between grandparents and grandchild.
You're saying that's under an equitable approach or under the new Parentage Act?
That is both, Your Honor.
Okay.
So under the equitable portion, right, because that's where we're considering this, it's not about names, wouldn't you agree? Whether you call somebody X, Y, or Z, it's about, are you standing in the role of a parent? Are you doing the things that parents do for their children versus kind of a nice neighbor or a nice aunt sometimes takes them out, but what they're doing on a day-to-day basis that creates that parenting role. Right? So in other words, if you're always called granny, but you do every single thing that a mom would do, you think that's not good enough because they call themselves granny.
Your Honor, respectfully, it is not what I think or what I would call it, but rather what the law has very clearly said. Both the common law and the new MPA are very clear that there must be a holding out of the petitioners as parents, not as any
But my
other.
question is it just in name alone? Because if a grandparent does everything that a parent would do other than use the name mom or dad, that you say they don't qualify as a de facto, because then who would qualify? The neighbor who takes the children for X amount of years and the parents leave and go to Florida and they do everything that a parent would do? I guess unless everybody's calling 10 people mom and dad, I don't see how you could apply that and rule out de facto parenting because of a moniker.
De facto, the concept of de facto parenthood evolved at a time when the law did not adequately recognize same-sex or queer relationships. And that is where we get the case law in Massachusetts around that concept.
So you don't think it applies to grandparents?
Does not, Your Honor. And the statute for grandparent visitation could apply in most circumstances to grandparents, but it cannot here, as Justice Brennan stated earlier, for criminal reasons.
So can I ask, so I'm reading, again, the cases that I looked at to figure out when I'm processing, what are the elements of a de facto parent? How do we establish de facto parent? And what I came up with was, number one, child resided with the de facto parent, here the grandparent. 2, with the consent and encouragement of the parent, here the mother, the de facto parent performed a share of caretaking functions at least equal to or as great as the parent, here the mother. And 3, that the de facto parent shaped the child's daily routine, addressed the child's daily developmental needs, disciplined the child, provided for the child's educational and medical care, and served as a moral guide. What am I missing? Because it doesn't say there, put themselves out to be the parent. It says that definitely in the Act, but it doesn't say that in any case I could find.
If I could just make one very important point regarding interpretation of equitable matters. Once there is a statute put into place, appellate courts and then trial courts should use the statute to guide interpretation of equitable matters.
So that's interesting, because do you think that, I see how it applies to a trial court. I see definitely how it applies to, because as I read that, that when you're trying to determine an equitable solution, you should look at what the statute is. We're not making an equitable solution here. We're not doing equity. We're doing law. Now, we're certainly interpreting equity, right? Isn't there a difference?
If I may, I think the Boston Globe Media Partners case addresses that and says that appellate courts, too, can look at newly enacted statutes that were enacted after the trial and before the decision in the appeals or SJC.
So
it says, can I just, I'm sorry, and then I won't step on you one more time, because I looked at that case and it says equitable proceedings take note of events occurring after the commencement of the action. This is not an equitable proceeding here. It should be. We'll try to be fair, but it's not an equitable proceeding.
And if it is not an equitable proceeding, then if we are only bound by the common law, that too gives rise to much support for my position that we have to look at whether there is a parent-child relationship. It's rife throughout all of the case law. It's very clear in age versus MP and in E&O versus LMM and even in Smith versus Jones, that there has to be an outright consent. I don't know if I would go so far as to say unequivocal consent, but there has to be consent to the formation of a parent-child relationship. And it's also important to note, as the Smith versus Jones case and the ALI standards are very careful to say, it cannot be something that a parent falls into on accident.
Can I, before I step on, no, because I'm going to let, I don't dominate this if I'm,
It's okay.
you're good? So don't you think there's a difference between an outright consent or even a consent to a parent-child relationship and putting oneself out as a parent? I think those are distinctly different concepts materially, no?
My client consented to the assistance of grandparents. She did not consent to having two other parents step into her parent-child
But as a
relationship.
legal concept, outright consent to the parent-child relationship is a different analytical framework, it seems to me, than putting oneself out as a parent. Because as you say in here, clearly at the school, the mother had to sign off on the school, right? So she didn't put herself out, the grandparents didn't put themselves out as the parent, but that doesn't really necessarily inform us as to whether the mother gave outright consent or unequivocal consent or any sort of consent to the parent-child relationship.
She never consented in either way. She neither held out nor consented to them taking on parent-child status, the grandparents, I mean, taking on a parent status. What she did consent to was the much-needed assistance that a 15-year-old would need to raise a baby. My sisters make much of the fact that my client was not the adult, and that's the exact phrase from their brief. She was not the adult who brought the child to medical appointments. I would like to remind the court she was not an adult at all. She was not even eligible to get a driver's license at that time. So she needed...
back to the whole tangle about unequivocal consent. Assuming that the mother, when she was young and the child was young and not yet in school, freely consented to the child living with the grandparents, but then at a certain point, the mother got a little older and became more stable, and the child was school age now, and so the child's time was limited and more structured, and the mother then decides, I want to have the child with me. Even, is it unequivocal consent or is it consent at all if the mother consents to individual dates of the child living with the grandparents but doesn't consent to their becoming the de facto parents? Do you understand my question? Kind of long.
I believe I understand it, and if I could, I'll give you an answer that I hope is one you're looking for. You can tell me if it's not, but not only did she not consent to the formation of a parent-child relationship, the time when the child was in school is when you begin to see the real unraveling here, and that is when my client mother was texting frequently with the biological father and saying, I don't agree, they aren't parents, things like that, as you will see in the judge's findings. And she was saying, you know, I don't agree to this. I want to have more time with the child. But she finds herself without a real mechanism to put that into effect at that point. She had been effectively cut out. And the judge attributes that in part to the domestic violence, and perhaps there was not voluntariness in all of this. So I would say that it's not consent to any of that occurring at that point. But the relationship between the grandparents and the child had been formed. We don't deny that. I would like to answer a question that Your Honors posed earlier. To my understanding, and even when we checked last week, the child is seeing the grandmother in accordance with that informal agreement that we submitted to the court. The child, I believe, is seeing grandmother at least once every other week for an fairly extended period of time. That does not seem like an abnormal grandparent-grandchild relationship to have. And I would also like to point out that the petitioners, when they brought this matter, one of the reasons my client and we were so confused about the procedure, if any, that the trial court was applying, none of these factors or standards were clear at the outset. And at that time, the grandparents were saying that they were looking for custody of the child. Now I see that it has been walked back to visits, which again, make of that what you will, but that would seem to try to place them into the grandparent visitation statute that they know they can't meet. And we cannot use equity to get around the limitations of any statute.
I have a housekeeping type question that I meant to ask one of the appellant's lawyers. The transcript of the judge's interview in camera with the child is reference to an unidentified speaker. Is that the child's lawyer? Do we know?
We were not allowed in chambers.
I'm getting a nod. So.
And I believe that it was, though.
Okay, thank you.
Yes.
I know we're a little bit overcast. One more question. One more question I have for you. Do you think we, as the Intermediate Appellate Court, have authority to do a Blick-style rewrite of a statute? And do you have any cases where it was ever, I saw a bunch of SAC ones, but I did not see anywhere where we did that.
Yes, Your Honor. I am not aware of that either, but that really is the guidance that the trial courts will need, given that the new statute, the 209C Section 25, around de facto parents, is terrifically unclear, to put it politely, and is perhaps a constitutional trap for many parents.
You did give a crack at direct appellate review, and they said no thank you, right?
Unfortunately,
Should
yes.
we take a hint from that, or I'm not sure? Well, it's a rhetorical question.
I believe there are other mechanisms by which this case could now reach the SJC, and if Your Honors are inclined, I would suggest that maybe that is the proper place. However, I see that I am way over time. Oh.
I have a question. I asked counsel for the child about this. There's some dicta or a footnote in Guardianship of KN about the child may not have standing to appeal, but we're going to reach the issue because it's capable of repetition, evading review. Is this case one that's capable of repetition, evading review, or is it dependent on the unusual fact scenario of the father not being willing to provide parentage and therefore the grandparents not fitting within the grandparent visitation statute?
To answer the hypothetical with my opinion of what I see in the probate and family court, I do believe that this statute has unfortunately swung the doors wide open to any third party in violation of Troxel.
The Parentage Act.
Yes.
But doesn't apply here. I'm focusing on the question of the child standing to appeal and whether or not it's likely to arise again that in a non-Parentage Act situation, based solely on the equitable powers of the court, there's going to be a scenario where the grandparent statute doesn't, the visitation statute doesn't apply, so we should reach the issue even though maybe the child doesn't have standing.
If we are narrowing it down to the grandparents, unadjudicated grandparents, if you will, needing to use some vehicle to come into court, I would suggest that that would be confined at most to approximately 26% of non-marital children, because that's the percentage for whom there is no voluntary acknowledgement of parentage and no adjudication of parentage at or near the time of birth. It's about 26%. Last time I checked. That is still a fairly substantial number. Last time I ran the numbers for a different case, that was approximately 33,000 children per year in Massachusetts who maybe possibly their biological paternal grandparents could attempt to use this mechanism to come into court to evade the grandparent visitation statute.
Thank you both. Very well argued by all parties. Thank you very much. This is a very interesting, difficult case. And with that, we will turn to our last case. It is 2025 P1149, New DIA LLC versus CR Operator Holdings LLC. Good afternoon.
Good afternoon. The time, oh, there it goes.
We need to reset.
May it please the court.
If you could pull the microphone, thank you.
Yes, Your Honor. May it please the court. Colin Hagan on behalf of the appellants. The trial court's decision denying leave to amend and dismissing the action should be reversed for at least 3 reasons. First, whether Vicente owed appellants fiduciary duties under any of the 3 theories that were alleged is generally a fact issue. Somewhat, to some degree, it can be styled as a quasi-legal fact issue, but it's usually a fact-driven decision that is often addressed on a much more developed record, not at the pleadings. The cases that we've seen are usually after trial or at least on summary judgment. Second, appellants plausibly allege that Vicente agreed to take on 3 roles that give rise to a fiduciary or at least contractual obligations, those being an escrow agent, joint regulatory counsel, and a common law agent. And third, to the extent that this is a matter of the trial court's discretion, the court abused that discretion in basically adopting adverse inferences that are not reasonably inferable from either the previously existing first amended complaint or the proposed second amended complaint. And because the matters or the claims alleged were not futile, there was no other good reason to disallow amendment at that stage of the case, which was essentially still at the pleading stage.
I have a question for you about the first amended complaint and the second amended complaint. I noticed that the second amended complaint is not signed, and it has the watermark draft across it. When we write an opinion in a case involving a motion to dismiss, we take the facts alleged in the complaint in the light most favorable to the moving party. Do we do that as to the second amended complaint that's not signed and is a draft?
Yes, you do, Your Honor, because that is addressed under Rule 15. This was a motion to amend. There had been a prior motion to dismiss that the court essentially combined and collapsed in its review, but I think that the decision is described in the context of a motion for leave to amend. And so in that case, the court is looking at it in the same context as it does as a motion to dismiss because it's determining the issue of futility.
So if the judge had wanted to allow your motion to amend, could they have just taken that second amended complaint with draft and no signatures and put it in the docket?
Well, I think what happens, in my experience, what happens is you propose an amendment, but you have to show the court what you're proposing you want to file. And you often do that with a red line so that for the ease of the court and the parties to show these are the changes that we're proposing to submit. If the court looks at that draft pleading, what you're proposing to submit in the context of deciding, is this futile, meaning is it not something that would be allowed as a matter of law? Is it not something that reaches the Iannaquino pleading standard? And
how do we know that the allegations in that second proposed amended complaint are true if nobody ever signed the complaint?
Well, because I think when you're representing to the court that this is exactly what we want to file, you're inherently making that same representation, whether it's through counsel or whether it's, by virtue of the party. When you attach that to your pleading, the counsel subscribes to it and says, this is what I'm asking for permission to file. And in my experience, when the court grants that or allows it, then you take exactly what you said you were going to file, you sign it, you submit it, and then it's on docket.
So if we said the judge should have let them file it, you'd just go accept all the changes in the red line and sign it and file it. And somebody would have to go through it line by line and make sure it was the same?
Well, no, I think that's the inherent representation. I would never file something other than what I had proposed to the court.
Why not just file something signed?
Because I think at that point, the courts won't allow, the docket, I think the clerk will not accept it because you're filing something signed that you haven't received leave to file yet. And so that's why when you look at the court's decision, it is referring to the proposed allegations in the second amended complaint, essentially accepting them as true for the purposes of the decision because it's assessing whether it's futile. This is not a case that was past discovery and the court's trying to assess prejudice or timeliness or some of those other thorny issues. This is at the threshold, and so the court's primary focus is on futility, and that is why in that context the court's looking at it.
Would the judge have ruled that it would prejudice the plaintiffs, sorry, I have the parties wrong, it would prejudice the defendants to allow the amendment or to allow the acceptance of the second amended complaint because you already had one shot and that's what the rule allows you, and you're not even attesting to this draft, unsigned, proposed amended complaint, and that would be prejudicial?
Well, I didn't understand the court to be reaching that.
I'm not saying that the judge did say that. Could the judge have said that?
No, I don't believe so, because again, my understanding is that the proper procedure for when you're seeking leave to file an amendment is to submit the proposed amendment, but that you can't go ahead and file it because you don't have leave yet.
Okay, so I have some questions about, speaking of unsigned documents, there's some references in the record to what constituted the closing documents and the ancillary closing documents. And I understand that at least the First Amendment amended complaint says that those included on the part of the buyers, or the plaintiffs rather, it was a seller's certificate, a bill of sale, an operating agreement, a post-closing licensing agreement, and an advisory agreement. Were those executed or not?
My understanding is that those were executed by the sellers. The sellers executed them. They were supposed to have been executed also by, well, the ones that were applicable to the buyers were supposed to have executed them as well, and that's where some of this issue arises, because Vicente informed the sellers that they had been executed, that they were holding them. Later, after this all unraveled, they said, actually, we don't have any signed documents. And the sellers, the appellants, said, well, you at least have the documents that we signed. You told us that you had the other documents. And that's where a lot of this issue and uncertainty and some of the issues with respect to fiduciary obligations of disclosure arose, because there's, first of all, there's either some misrepresentations, there's some other conduct that we don't know about that is, well, we had them, but now we're just not going to release them, although...
But so, as I understand the record, and including the complaint, Vicente told both sides before they went to the CCC for approval of the transaction, we shouldn't sign the documents yet because we could run afoul of the CCC if it looks like we've already consummated this transaction. But you're saying your clients did sign the documents.
Through DocuSign. And I think that's the issue, is that it's not that they weren't necessarily signed, it's that they weren't exchanged and merged, although, again, it's somewhat confusing because of what they were told beforehand and what they were told after the point. But what's alleged in
So if, assuming that the documents were not signed by Vicente's clients, are you saying that Vincente had a duty to your clients to make their clients sign the documents?
Well, they were supposed to have gotten them signed in the first place. First, that's what the underlying agreement specified, that they were going to be signed on the date of the agreement. And then if Vicente's the one advising both parties as to this regulatory, these regulatory sequencing to, again, not run afoul or suggest that you've closed the transaction that you don't have leave for, that's what they represented, is that you're supposed to sign these, but you're not going to merge them. That's why you're going to come together at the closing and exchange these signed documents. And that's why only certain documents were submitted. And it just so happens, and again, you look sort of in hindsight, what appears to have occurred is that the documents that, at least depending on when you believe Vicente and what it's telling us at the time, the documents that were signed and executed appear to be the ones that only bound the seller. There was a construction note, there was a licensing agreement, there's of course the underlying transaction document, but the bill of sale, the seller's promissory note, in the operating agreement weren't executed. And of course, that's highly prejudicial. If you're talking from one client to, a counsel representing two clients, That's prejudicial because that causes the other party harm. You don't have signed documents that you can go and sue on or, allege that you've got this agreement. You have...
But isn't it ironic that your argument is focusing on the fact that these documents maybe weren't signed and your second proposed amended complaint isn't signed?
I don't believe so, Your Honor, because my understanding of when you're seeking leave, if you're exercising your first free amendment, of course, you sign the document, you file it. If you're past that and you have to seek leave to amend, then you don't go ahead and file the same document that you've already, that you're seeking leave to file. And again, I think when you're asking and attaching the document saying this is what we want to file, you're subscribing to it, you're representing to the court, this is what we want to file. And that's why the court, in assessing futility, is citing to and looking at the proposed allegations in the proposed second amended complaint. That's why, all the citations in the court's memorandum opinion are to the second amended complaint, and it's focusing on what's the proposed allegation.
But how could the judge dismiss the second amended complaint if it was never permitted to be filed?
The way I think that reconciles is that he didn't allow it to be filed. He denied leave to amend, and he dismissed the existing complaint, the first amended complaint. Part of some of the other parties had already been voluntarily dismissed because of the arbitration, but Vicente was left standing, and the operative pleading at that point was the first amended complaint. And so, for belt and suspenders, the court denied leave to amend and dismissed the then pending operative complaint. That's why it's kind of a combination of leave to amend, denial of leave to amend, and dismissal of the remaining action. But
so it sounds as though you're saying that when we set out to write an opinion of this court and lay out the facts in the light most favorable to your clients, we should rely on the second amended complaint that's unsigned and was never accepted for filing.
that's correct as to the issue of whether the court should have allowed leave to amend, because that's exactly what the court is considering on the futility analysis.
But under the 12b6 analysis.
And it's when the court is assessing futility in the context of a request for leave to amend under Rule 15, it is applying the same motion to dismiss standard, looking at Aquino for the pleading standard and otherwise looking at other factors that may assess prejudice. But again, at the pleading stage, and we've cited the Chang versus Winklevoss case, that if it's not futile and there's no other good reason to disallow the pleading, then it's essentially abuse of discretion to deny a motion to amend given the liberality of amendments specified under the rule. And here you're at the pleading stage. This is not a situation where it's at the 11th hour right before trial or anything. Focusing on the allegations plausibly plead that there are these various commitments, various causes giving rise to fiduciary duties, whether that's as the escrow agent, qua escrow agent, whether that's as joint regulatory counsel, or whether that's even as a common law agent. Many of these same issues were, I think, still plausibly pleaded under the First Amendment complaint. They were more robustly alleged and described in the Second Amendment complaint. But these, the court's conclusion that that this was essentially, this is where I think the court erred and abused its discretion in essentially even finding what are essentially adverse inferences, finding that that this was just an escrow agreement, that this is common in transactions for one party's counsel to provide some ancillary service in terms of collecting signatures or some ministerial act, in a transaction, or even finding that as a matter of law that one party cannot rely on an adverse party's counsel, given what was alleged that this was something that was part of a common goal that all the parties were aligned on. It didn't fall within the prior adversarial stance that you would have, when they're negotiating the underlying agreement as arm's length parties. And so this case is highly analogous to the Williams v. Eli case that we've cited, the Bertolino case, although that's a trial court decision. And it's essentially the inverse of the Horvath case, which is the sort of conventional escrow agreement situation, or the real estate transaction that this alleges far more different allegations than that type of conventional transaction. Thank you for your time. I appreciate your time.
Thank you.
Members of the panel, may it please the court, Ed Landers on behalf of the appellee, VINCENT LLP. With respect to the crux of the matter is that VINCENT was representing the buyer in the transaction, solely the buyer in the transaction, and its only obligations with respect to escrow duties were from the membership interest purchase agreement, which I'll refer to as the MIPA. As far as the MIPA is concerned, Section 2.6 provides that VINCENT's duty was only to hold whatever documents it received in trust until the closing, at which time VINCENT shall release the documents. So VINCENT's duty was conditioned on there being a closing, and the parties being the CRO parties, VINCENT's client, and the plaintiff, the new DIA parties, those are the entities that controlled the manner of the closing, and that's pursuant to Section 2.4 of the MIPA, in which it states that the parties of the transaction were the ones that would be able to set the terms of the closing. The actual language says that the closing will be at a time and place agreed to by the parties unless the parties agree that the closing need not occur at a specific location, and the closing may occur by the remote exchange of executed documents. So with respect to the escrow duties that VINCENT had, it would only be triggered by the closing itself, in which they would release the documents.
So are you saying that in addition to the approval by the CCC, that agreement about a closing is another condition precedent to closing?
That's correct, because Article 6 of the MIPA provided the conditions that would allow for a closing, and one of those specific conditions was approval by the CCC. And the approval by the CCC required an application, and the application from the CCC specifically said, failure to obtain commission approval prior to making a change of ownership and control may result in a license being suspended, revoked, or deemed void. So VINCENT's guidance was entirely reasonable in terms of saying, before we start going ahead and signing off on closing documents, you need to make sure that you first get the CCC approval. They structured it such that through their advice to their own client, in terms of then the plaintiff benefited from that advice because it assisted in terms of getting the CC approval. But it was important to make sure that all that was executed in advance of the approval was the membership interest purchase agreement and the pre-closing licensing agreement. So those two documents were executed, and those two documents were what the CCC approved, and VINCENT was entirely successful in obtaining
And those documents were not only executed, but were they given to the CCC, so they were not in the escrow black box that your client was holding?
That's correct. Those are what was presented to the CCC. So therefore, the CCC realized those documents were in place, they approved it, and then that was what then triggered, that was one of the last conditions for the actual closing to take place. And then for whatever reason, which reasons don't matter as far as VINCENT's duties, the parties did not consummate the transaction through the closing itself. And again, VINCENT's duties were solely, if there's a closing, then the documents would be released. And this notion that somehow VINCENT took on some kind of common law agency, that flies in the face of the clear statement in Zhang that although it's a Massachusetts Appeals Court case, Zhang, which is cited in the papers, that says that basically that although there might be fiduciary obligations owed by an escrow agent, it doesn't result in making the escrow escrow holder an agent of the parties. So this notion of a common law agency it flies in the face of the case law.
I don't know if it matters, but do we know from the record whether all of the documents being held by your client were executed?
We don't know that from the record, Your Honor. And that was kind of the whole crux of the underlying case, because when this case was filed, it was also filed against the CRO parties. So the new DIA parties were trying to seek declaratory relief against my client, trying to get them to divulge whether or not there had been closing documents executed by their client, whether or not there had been disclosures as to whether or not they were willing to go forward with the transaction. Those were all attorney-client communications. So the trial court, the lower court, was faced with the issue of a real breach of the attorney-client privilege if these kind of issues were divulged. And that flies into the issue of the fact that trying to take what Vicente did in terms of Vicente being completely successful in getting their CCC approval, and then trying to turn on its head to then say that somehow they're going to be entitled to get at attorney-client communications by virtue of trying to say that, oh, you're also our counsel as well, despite the fact that they're represented by not only Massachusetts' well-respected counsel, but also they even have a consulting firm, a cannabis consulting law firm out of state that's also consulting. So they were certainly well represented. They certainly had plenty of advice of counsel, and there was no reasonable expectation of Vicente's part that they would somehow be relying on them. And also, moreover, in their own brief, in their opening brief in page 41, they actually concede that once the CCC approval was obtained, that then the parties, their quote is, the parties resumed dealing at arm's length when buyer refused to close. So as soon as that CCC approval was obtained, and then the parties went back to resume, even they acknowledged that the parties were back to dealing at arm's length, which Vicente always understood that the parties were dealing at arm's length with one another. But if they had some kind of false expectation that somehow there was some duty that Vicente owed to them, they, by their own brief, have acknowledged that there was no longer any kind of expectation, and then that then goes right in the very fact that certainly Vicente couldn't have disclosed any of those attorney-client communications. And moreover, I mean, the notion that I saw in their reply brief, they get into the case of KG Custom Homes and they cite Stormo. That's all the same transaction counsel in that case. In that case, in those facts, the seller's counsel in that case was hindering the closing. No question of hindering the closing in terms of taking a promissory note and holding it within 2 feet of the opposing counsel's face and not allowing him to actually handle the documents. Vicente certainly didn't know any of those kind of antics here. Vicente did what he was supposed to do in terms of representing his client, acting as escrow agent, and fulfilled the duties he was able to fulfill. And I mean, really this case boils down to I think the English proverb, you can lead a horse to water, but you can't make him drink. And that's kind of what happened here, and that Vicente brought it up to the point where the parties could close, and the parties did not close. And the
horse.
Well, I'm sorry?
Who's the horse?
The horse would be even Vicente's own client.
Okay.
Because if Vicente's own client decided for whatever reason to back out of the transaction, then it certainly has its right to do that, and then it runs its risk of McCarthy versus Tobin and all those cases that say, look, once you have a membership interest purchase agreement that's in place.
And that's the arbitration.
That's the arbitration. That's something that's not in our wheelhouse. That's nothing that we're involved in at all, Your Honors.
What do you have to say about the amendment of the complaint?
A very good point you raised, Your Honors. It's something that I've seen it more so than not. I can't stand before you and say I've never seen it unsigned, but I've seen it more signed. And once it's signed, then it's already docketed. So it's all packaged to the court, it's signed, and then it just gets served on the other side. And it's just served, once it's been amended, it just gets served by virtue of email or whatever. It doesn't even have to be formally served.
But I guess my question is, as an appellate court, when we're looking under 12b-6 and Yanakino and all those cases, at what are the facts in the complaint in the light most favorable to the appellants, which complaint do we look at?
Yeah, I mean, I think I'd have to do that, compare right versions of the two complaints and go back and look at it, but I think a lot of the allegations, the first complaint had all the allegations were focused on the CRO operating parties, very little said about Vicente. The second amended complaint still has a ton of allegations against the CRO parties and very little against Vicente. In this case, they kept on adding layers as once Vicente would not divulge the communications. This case started out in the first amended complaint was only declaratory relief. Then 2 more counts were added.
Specific performance. I think the first one was specific performance.
Declaratory relief in the first amended complaint.
Okay. Oh, yeah.
And then the additional counts were added were the breach implied covenant of good faith and fair dealing, I believe, and then there was one other count that had breach of contract, I believe. And then it was even expanded further to add 93A and all this stuff once they didn't get the attorney-client communications that they were trying to seek by way of the declaratory relief, which is the original way. There was very little said in that in the very first complaint, the original complaint. There was very little said, if anything, about Vicente. I think it was just, all it was declaratory relief. And I think it was the premise was that they needed us because, and they needed my client, Vicente, because of the fact that Vicente was involved as the escrow agent. But again, Vicente couldn't do anything without a closing. So this case is, the fact that Vicente has been, dragged through this entire case and through various many complaints and whatnot, it just shouldn't be happening. And I hope that my client hopes that you'd affirm the trial court's decision, which is very well-reasoned and very thorough.
Thank you very much.
Thank you.
That concludes our sitting for the day. I want to thank the parties. That was very well argued. Complex case, but very interesting. And I want to thank the court officers and the law clerks and the clerk's office that were here earlier for a wonderful